Any answering? Partial impingement, item number 1.
But the witness action matter, my lord. No, my lord. The affidavit of evidence on behalf of the plaintiff is ready. But being a government company, the original documents has to be traced out. So that has got my difficulty. So my lordship already granted me an extension for filing the affidavit evidence. So the original documents which need to be exhibited, I need lordship's pleasure to keep it after 12.
Is for the defendant.
My lord, I'm for the defendant.
We have shifted the sides. That's the difficulty. I think I should stand in this side, the plaintiff side. Shit, that's the confusion I'm creating. I'm creating the confusion. It's 12th or 19th, whatever the Wednesday, 12th or 19th. After my lord's.
Mr. Aniruddha Mitro, and senior advocate appearing for the plaintiff, seeks accommodation to file examination in chief on affidavit of the witness on the ground that some of the documents could not be traced out. What is this matter? Kabe jabe? 19th.
Much of that.
New chamber application, item number 2.
Wait, please, Your Lordship. I am for the plaintiff. We have taken out an application with an innocuous prayer, my lord, which is IAGA 5 of 2024. You know, the fact of this petition, if Your Lordship, my lord, comes kindly takes up one, my lord, intimation. It's only for change of the name. But kindly take up page 8 once, and I'll indicate, my lord. This is GA 5, page 8. The defendant informed us that the name in the registrar of companies has changed of the defendant. But kindly take up page 9 once, and I'll indicate. This is defendant number 2, my lord. Page 9 is the certificate of incorporation. Kindly see the name NSE Clearing Limited. At page 9, first paragraph, my lord. Page 9, my lord, the first paragraph, I hereby certify the name of the company has been changed from National Securities Clearing Corporation Limited to NSE Clearing Limited. Page 9 of GA 5, my lord. Certificate of incorporation. My prayer is innocuous. My lord,
It will be defendant number 1.
defendant number 2, my lord.
Okay.
Now kindly see my prayer at page 6. Prayer B, my lord. Leave be granted to amend the plaint in terms of C. Now C is, my lord, where we have carried out the correction. It starts from page 11.
Okay.
Page 11 of the petition.
Any affidavit of
Defendant
service? Affidavit of service?
My lord, I appear for defendant number 1 and 2 virtually. But somehow my the webcam is not working. My lord, I have no difficulty. Let the amendment
I'm
take.
sure my learned friend will not object to this. My
One.
lord, it is only this.
You are 1 and
1 and 2.
1 and 2.
2. 2 means 2 you are seeking for
My lord,
amendment.
the page 11 is, my lord,
And
the
what about
amendment
3?
which is carried out.
3 has been served, 3 and 4.
3 is not appearing, my lord. It's
4 sir.
4, my lord, is also not appearing. We have served, my lord. It is there. The affidavit of service has been filed. It is always
Okay.
defendant number 1 and 2 who are appearing, my lord, in the proceeding. From the very inception, my lord. In fact, my lord, defendant numbers 3 and 4 would not have any objection. It is only with regard to the change of name of defendant number 2.
Okay. This is an application for application seeking amendment of the name of defendant number 2. This when so learned advocate appearing for the plaintiff submits that the name of defendant number 2 as per the certificate of incorporation issued by the Ministry of Corporate Affairs, Government of India, has been changed from National Securities Clearing Corporation Limited to NAC Clearing Limited. And to that extent, the amendment is to be carried out for changing the name of defendant number 2. Para. Mr. Wenso, learned advocate, appearing through virtual mode, does not raise any, appearing on virtual mode on behalf of defendant number 1 and 2,
And 2, yes.
raise any objection. Considering the amendments made in the application and also the documents, namely annexure A, appended to the application, let there be order in terms of prayer B, C of the master summons. The department is directed to carry out the amendment within a period of 4 weeks from date of communication of this order. Application being GA-Com 5 of 2024 stands disposed of.
I'm very deeply aware, my lord. There's an order on 21st of September, therefore inspection and discovery, my lord, to be carried out 21st of September 2023, and also for framing of issues.
My lord,
Lord-
let it come, my lord, after 4 weeks, let it be returnable.
The next date may not be made returnable, my lord. In the meantime, my lord, if there's an order for completion of discovery and inspection
After
as well as the framing of issues.
after the amendment is carried out, you mentioned thereafter past
Yes,
direction.
yes. That will be,
I only
yes.
one indulgence was only to expedite the process, my lord. Instead of 4 weeks, if it is 2 weeks, my lord, it's only a formal change. My lord, we can mention after 2 weeks.
Okay. ठीक है, 2 weeks को.
I'm very deeply aware.
Grateful, Lord.
Item number 3.
Please keep it a short pass over.
Item number 4.
তো জাজমেন্ট দেখাতে দেখাতে সেদিন বলবি কখন দেখবি?
That matter where during when the evidence of the first witness for the defense was going on, the suit was transferred to commercial division. So now my learned friend has come up with an application.
No, one catch is there. Before the suit was transferred, the witness was in the box, and thereafter the COVID period came in, and the witness retired, and after that he had COVID and he is unwell and he has refused to come. So the position is that chief is half done, certain documents have been tendered, and your lordship knows the witness was not offered for cross-examination thereafter. So that evidence which has gone in has no evidentiary value. So now I cannot rely on those documents which have already been tendered. So my prayer was to return those tendered documents and I will retender it through a new witness. I have a right to produce as many witnesses as I want to, but those documents which were tendered and marked as exhibit cannot be looked into, since it was not offered for cross-examination and has no evidentiary value. That is the reason I prayed that those documents may be returned and I may retender it to my next witness. Well, to which my learned friend objected. Well, thereafter, on the last occasion, I made my submissions on facts. My learned friend was relying on a judgment which was not available at that point of time. So today he has to place that judgment.
Lordship be kind enough to pick up the yes, to the master summons once again.
Yes.
Now, relief A if I may, my lord, please. The evidence of so and so, the witness of the different numbers 2 and 3 already on record be expunged or should kindly or therefore no. This is the first part of relief. Relief is in two parts. First is be expunged. Now, in support of that, as my learned friend has right now also pointed out, one should find that at paragraphs 13 and 12 of the application, one should kindly consider paragraph 12 and 13, what was found? Page 6 of the application. That's found page 6, paragraph 12 and 13. Now, paragraph 13. I further state that it is a well settled principle of law that the testimony of a witness is not legal evidence unless it is subject to cross-examination and where no opportunity has been given to the other side to test the veracity of the witness. The evidence of such a witness is not legal testimony and cannot be the basis of a judicial pronouncement. So this is the legal proposition my learned friend is advancing. On the basis of that, they say the last part of paragraph 12, as such, the evidence already on record cannot be looked into as honorable court, as the said witness was not offered for being cross-examined by the plaintiff. So, my lord, everything apart, I will come to the facts. Everything apart, my lord, this is the legal proposition they're relying on. Now, whether, my lord, this legal proposition holds, my lord, what else? Whether the legal proposition is that the testimony cannot at all be looked into, or whether the proposition is this, that I ask myself, my lord, that the court would look into whether credibility, whether weight can be attached to that evidence, instead of ignoring that evidence altogether. First judgment I seek to rely upon that is reported at AIR 1929, Lahore 840. Would kindly turn the page at paragraph 6. Just one paragraph 6. May I, my lord, please? The evidence of so and so is more direct. He himself being the borrower, alleged borrower, but a difficulty has arisen in this instance. He was examined by the prosecution and no cross-examination was put to him. After the charge, it was discovered that he was so ill that he could not travel from Meerut, and when interrogatories were sent to him, he was not in a fit condition to answer the questions put to him. The result is that he was never subjected to cross-examination. It was contended on this account that his evidence cannot be considered because the statement is incomplete. Some authority was cited in support of the contention, but the facts are similar to those stated in a passage at pages 137 and 138 of Maharaja Kolhapur versus Sundaramaya. The correct rule, according to that authority, is that such evidence is admissible, but that the weight to be attached to it depends upon the circumstances of each case. Now it is clear from the interrogatories that although it was thought to show that P.L. Jaini was a friend of the applicant, there was nothing in them that referred to the signing of any application for a loan, nor was there any correspondence on the subject. So and so was a member who is a member of the bar and an operating magistrate was not likely to have lent himself to what amounted to a fraud on the shareholders or to have rendered himself without any safeguard liable for a debt of so and so. His denial, therefore, though not subjected to cross-examination, be taken into consideration and should, in the absence of rebutting evidence, and there is none, be accepted as true. So the evidence is admissible, even without cross-examination. But whether or at all any weightage to be attached to that, that would be considered the appropriate. Now, this judgment, my lord, refers to, as Lordship has found, a judgment of in Maharaja of Kolhapur versus Sundara Mayar. Now, this is, my lord, reported in EIR 1925 Madras 497. Now, this is, my lord, I must say, this is a voluminous judgment. My lord, come back to this. The next judgment, my lord, I rely upon is reported in EIR 1936 Patna 34.
Yes.
Now, Lord, should kindly consider paragraph 1 itself. Fourth line from the top.
Paragraph
Paragraph 1.
1.
What had happened? The fourth line from the top and paragraph 1. The courts below have decided this question in the affirmative, relying on the evidence of Jailal Pandey. If the courts were right in considering the evidence of Jailal Pandey, the whole case is concluded by the findings of fact. But it is contended that the deposition of Jailal Pandey was not evidence and should have been expunged from the record. The deposition was not taken in open court but recorded by a commissioner, the witness being too ill to come to court. He was examined in chief and cross-examined in part. The cross-examination was adjourned and the witness died before cross-examination could be resumed. Courts below have relied on the note in Ugraf and Amir Ali's Indian Evidence Act to the effect that where the witness dies or falls ill before cross-examination, his evidence will be admissible, though its weight may be slight. Now, Lordship would kindly turn to paragraph 3, the next page. In India, decision bearing on this pointers kindly. One case, 5 CW and 30, where the cross-examination was incomplete, a deposition was excluded from consideration. It does not appear that this case was ever fully reported. I cannot find that it has been followed. In 16 CW and 991, the fact that a witness had not been cross-examined was held no part to the reception of his deposition in evidence. In that case, the opposite party perhaps willfully abstained from cross-examining. The decision in 48 Madras 1 is directly important. The question was as to the admissibility of the deposition of a witness who is stated, page 137 of the report, was ill when she was examined in chief and her examination was adjourned after few sentences cross-examination were recorded. She died before cross-examination could be resumed. Kumaraswamy Sastry Justice said, I do not think that the evidence can be rejected as inadmissible, though it is clear that the evidence untested by cross-examination on a question like the present can have no value. I think that the correct rule is that the evidence is admissible, but that the weight to be attached to such evidence should depend on the circumstances of each case, and though in some cases the court may act upon it, if there is other evidence on record, its probative value may be very small and may even be disregarded. This decision, which was followed in 1929 Lahore 840, which I just placed, seems to me, if I may so, with respect to state the law correctly, I do not understand the observations of the learned judge to mean that there is any hard and fast rule that the probative value of such evidence is small, and in my view, there is no such rule. The weight to be attached to the evidence depends on the circumstances, and the court should look at the evidence carefully to see whether there are indications that by a completed cross-examination, the testimony of the witness was likely to be seriously shaken or his good faith to be successfully impeached. In the present case, no circumstances have been brought to my notice which would tend to the view that Jailal's evidence was not entitled to weight. What he, then, my lord, after 2 sentences, what he deposed was, if he was interested at all against his own interest, and the fact that at the time of his deposition he was on his deathbed makes it, as the court below pointed out, unlikely he would have been actuated by an ulterior motive to distort facts in favor of the party for whom he deposed. Again, my lord, propositions repeated. Now, in this line, my lord, the last judgment I seek to rely upon, reported in 2018, 1 ICC 328. Now, Lordship would kindly straight away come to paragraph 3. What had happened in this case? On to and fro,
Para 3.
went through the same to and fro was again crossing the part and plus crossing the preferred on the pair of opposite part number 1 as instructed. To and fro filed a petition praying for closing the examination as PW. Now, principally, such petition and earlier is the same one company. And that it was explicitly for it obtain these supporting and attend court. It was for the station notification plus one to have seen the part surgery and notification and that is as that we are clarified by the 12th will be the order number for the cross examination of PW2 till the next day and get the petition for closure of evidence. Yes. Now, paragraph 6, second sentence. It was recorded with the order number 81 of the date that at the time of hearing, the learned advocate for the claim to decline petition of the evidence. Paragraph 6 from September, paragraph starting on September 27, 2013.
Six. You're reading from which judgment?
2017, this, I don't. There might be because I am reading from a. Paragraph 5 here. One paragraph. Yeah.
SCC online থেকেই পড়ছিস তো?
Lordship, would it be Lordship's pleasure to kindly consider
Yes.
copy this is online? From paragraph 6. It was recorded video order number 81 of the date. Lordship's found 81 of the date that at the time of hearing, the learned advocate for the plaintiff declined to adduce further evidence. The evidence of the same order. The trial judge also expunged the evidence of PW2 as the said witness did not come forward for cross-examination and November 29, 2030 was fixed for the evidence of defendant's witness. Then, my lord, paragraph 8. The plaintiff petitioner waited for several more days and only on December 1, 2016 chose to take out an application for recall of the order dated September 27, 2013, by which the evidence of PW2 had been expunged. Video order number 104 dated December 1, 2016, trial was rejected, so prayer for recall and the next date for carrying of arguments. Being thus advised, the petitioner has preferred the instant challenge against the order number 81 dated September 20. As well as order number 1, whereby the evidence of PW was expunged and the application for recall of such expunction order was rejected respectively. Now, Lordship would kindly consider paragraph 19, 19. For hearing both sides and considering the judgment cited as well as the materials on record and relevant provisions of law, the primary question which calls for consideration is whether the principle embodied in the explanation to order 17 rule 2 of the Code of Civil Procedure applies to non-party witnesses as well. It is not restricted only to party witnesses, that is, when a party to the case himself or herself adduces evidence. Consequently, whether the proposition rate to Pacific and Devar Park is applicable to non-party witnesses as well. Paragraph 20, the set of the provisions are set up. Then, paragraph 21. A plain reading of Order 17, Rule 2 and its explanation shows that where the evidence or substantial portion of the evidence of any party has already been recorded, the court may proceed on the premise that such party were present despite the party failing to appear on the day of hearing. This may give rise to valid interpretation that the party that such rider applies to different the rule of order 70, however, contemplates a situation where a party fails either to produce or to cause the witness of its effort. Such a situation, there can arise two situations. One where both the parties are present. First scenario where both parties are present, the court will proceed to be successful. In the second scenario, if one of the parties or both of them are absent, rule 2 along with its explanation will come into operation. Hence, comprehensive reading of rule 2 and 3 of orders rise to the inevitable conclusion that even when a party fails to cause the attendance of the witness as opposed to a party witness himself, the explanation of rule will apply by virtue of rule 3b. Consequently, when the evidence or substantial motion of the already discarded party witness, the court may proceed as if the party were present, even if such party fails to actually appear on the day of hearing. In the light of the aforesaid inevitable interpretation, either the factor cited by the petitioner or non-party witnesses whose evidence is substantial by virtue of the treaty of order 17. Thus, the judgment cited by the petitioner in the context of the explanation to order 17 rule 2, in particular, the judgments of the court. The contrast whereby the explanation to order 17 rule 2 and the latter part of rule 2 were introduced becomes academic and inapplicable. As such, the well-settled principle that the evidence of a witness will not be expunged, but its evidentiary value considered at the time of hearing, despite cross-examination of such witness having not been completed, holds good ground, even in the context of non-party witnesses. Therefore, the interpretation of Order 17, Rule 2, coupled with Rule 3, as sought to be argued by the opposite party number 1, is not tenable in the eye of law. So, my lord,
Yes.
these judgments read together, expressed by my lord, the proposition is this. Once a witness goes in, deposes, his evidence becomes part of the records of the court. Now, if the witness cannot be produced any further, for whatever reason it is, it does not automatically, it is not a given proposition that the evidence will be expunged. The court has to say whether any credence has to be given, what credence to what extent can be given to that witness evidence. There are another two parts to this, according to me, of what was subject to correction. First is, as far as the party on behalf of whom the evidence is being tendered, the witness is being established. That party can always contend that whatever evidence is already on record, that could not have been taken even in cross-examination. Even if cross-examination has been done in full and everything. Court has the authority, the court adjudicating matter has the authority to look into that aspect. That flows from my lord the older. Now, the other side, the adversary, who is supposed to do the cross-examination or rather would have the opportunity to do the cross-examination. That adversary can also contend that look here, whatever evidence has been given, he might not, the other party might not be able to use it, but as far as I am concerned, there are admissions, there are materials which I can use. Because Lordship would kindly consider the witness who has gone in on oath, he has already said whatever he had to say. Even if, now Lordship would consider the other situation, the usual situation. Even if the witness, the examination chief, cross-examination, re-examination full, it is not conclusive of the fact what credence will be given to that. That ultimately, apropos arguments, Lordship should decide that yes, Lordship just might decide that whatever this argument, whatever this witness has, whatever this witness had deposed, in fact, no credence is not worth anything. That happens every other day. So that question is left to the discretion of the honorable courts. What credence is to be given. But once it's part of the record, it is there. And the parties, how the parties can use it, whether the parties, to what extent it can be used. Because, my lord, this is The entire thing is on preponderance of probabilities. So in any event, even when the examination is entirely complete, deposition is entirely complete, the court has to consider what is the preponderance of probability, that this is the true version, considering everything. So this standard of examination is there always, but that doesn't mean that just because a witness has come in and has not completed his examination, so to say, it goes away just like that. This is the first part. Now, my lord, apropos that, what my learned, I will come to the facts, there's something else also here. Now, apropos that, now lordship would kindly consider the second limb of relief A sought in the notice of motion. The second limb in the notice of relief A.
Yes.
Yes. The evidence of be expunged and the said exhibits tendered by him during his examination chief be returned to the different numbers 2 and 3. Now, here, my lord, first, I am putting it, I know, very crudely. I ask myself, under what law? Now, we know there might be cases where a document is tendered, party requires it, then they provide photocopies, all those things are there. But this is not that. This is being said just because a witness who had introduced his documents into record, so to say, he is not there anymore. He is not there going to, the documents has to be taken off record and returned. But the documents have been already introduced. Now, of course, my lord, I would not arrogate myself to that position. My learned senior friend is there. It's a government of West Bengal at the end of the day. It's not my prerogative to advise. I am not. Lordship would not kindly take a miss. I'm sure my learned senior friend would not take a miss. But the witness who comes in, next witness, if somebody comes in, he can always talk about his documents. He can always say, because one part is the documents themselves. Second part is the witness is there. Any witness is there who is proving, so to say, the documents. But how to prove? The fact whether the documents are with my learned senior friend's client physically, or the fact whether it's in court records, does not really, my lord, in my most humble submission, take away from the legal proposition that the witness who comes in can, in any event, prove those documents, so to say.
Not true. We will identify the documents. Yes.
And I cannot, my lord, say any further.
That document can be placed to the
That's
witness.
not really my prerogative, my lord. That would be arrogating myself to something else. I don't want to do that. But the fact that once the documents have been already introduced, questions have been asked, that cannot be undone. That cannot be undone, not on this ground. There might be other issues that are not going because that issue has not been raised. So this is not a fait accompli that witness is not there anymore, so that can be returned.
Okay.
Now, something else is there. Now, lordship would find, lordship would kindly take up the petition once again, or lordship would kindly consider page 5. Now, I do not mind the place, but lordship would find from paragraphs 9 to 12, page 5 of the petition, or the affidavit rather. Paragraphs 9 to 12, this case has been made out that the witness has retired, the witness is unwell, the witness has made it known that he is unwell, and therefore he cannot be produced. And when I question that in my affidavit in opposition, in reply, we read to my learned friend, they have annexed a letter, two letters really, one a requisition from the government of West Bengal, or the defendant in the suit, saying, you please come and attend or give evidence. And in response, the witness has written apparently that, no, I am unwell, I have this, therefore I cannot do it, COVID reason. Now, my lord, without going into the merits of all that, I ask myself, my lord, under the law, just because a witness who is already on box has written to the party on whose behalf the witness was produced that I cannot appear, whether the avenue has been closed to the party to compel the attendance of the witness. Lordship would kindly consider, Lordship knows I won't place, Lordship would kindly consider two aspects. One is summons, where my lord sections 27 to 31 of CPC, particularly 30B, read with my lord order 16. As also, my lord, if the witness says, because Lordship would find that apparently the witness says that if I travel, and then there would be some difficulty. No, my lord, there is also, again, my lord, it's not my place to advise, but I am just pointing out that commission order 18, corresponding provisions in our original site rules, commission, everywhere is there. Now, both summons and commission, there is nothing in the application to say or show, because there has not been that the defendant, the applying defendant before your lordship, has taken any step to compel the attendance. Now, if the defendant had taken, the petitioner defendant had taken steps to compel the attendance of the witness, if the witness had come or witness had responded to that, or did not respond to that, and lordship was satisfied or whatever, then my lord, probably, I am not saying that then prayer A would be automatically granted. I am not saying that. But probably there's a scope that it can be considered. That's it. Today, my lord, I ask myself whether the case has arisen even to consider this, prayer A and all that. Because they have not exhausted their remedy. Both summons as also commission. Now, lordship would now consider prayer B. The plaintiff be directed to file his affidavit of admission and denial with regard to the documents disclosed in the defendant's judge's brief of documents within such time as may be deemed fit and proper by this honorable court. Now, my lord, it is absolutely right, my lord, that in commercial suits that are being conducted under the Commercial Courts Act, my lord, affidavit of admission and denial is a mandatory measure. That's true, absolutely. Now, lordship would kindly consider section 50, which my learned friend also subject to correction of the commercial courts as relied upon. May I, my lord, hand up? It's 15.
Yes.
Clause subsection 3, where any suit or application, including an application under the Arbitration and Conciliation Act 1996, relating to a commercial dispute of specified value, shall stand transferred to the commercial division or commercial court under subsection 1 or subsection 2. Provisions of this act shall apply to those procedures that were not complete at the time of transfer. And lordship also probably instructive, lordship would also kindly consider 4. The commercial division or commercial court, as the case may hold case management hearings in respect of such transferred suit or application in order to prescribe new timelines or issue such further directions as may necessary for a speedy and efficacious disposal of such suit or application in accordance with the Code of Civil Procedure. So first, my lord, from 15.3, that once it's transferred, they apply to those procedures that were not complete. Now, my lord, what is the statement that was transferred after myself? My witness at Ghani, the examination complete. Defendant's first witness has been introduced. The examination in the middle of this commercial division. Now, Now, Lordship would kindly consider when about the affidavit, at what stage the affidavit of admission and denial is to be filed. Lordship would kindly consider Order 11, Rule 4.
Yes.
Each party shall submit a statement of admissions or denials of all documents disclosed and of which inspection has been completed within 15 days of the completion of inspection or any later date. And of this procedure, and Lordship would consider statement of admission or denials of all documents disclosed. Everything that has been disclosed. Now, my lord, in this suit, pleadings were complete, issues were framed. Then, my lord, discovery inspection, the entire procedure has been completed. Then, my witness went in. Then, the defendant's witness, the subject matter of this application, my lord, went in. I asked whether this procedure is left to be completed yet. Because this calls for a stage when the witnesses have not gone in. The documents are there, the documents have been disclosed, documents have been discovered, then the parties are called upon to admit or deny the documents according to A, B, C, D criteria, so that, my lord, the entire process can be shortened. And for that, my lord, the legislature has also, my lord, in the after that sub-rule 1, 2, 3, 4, 5, 6, the measures are there. Now, in this case, I have already proved my documents. Some documents the defendant's witness have already proved. There cannot be any scope for application of this any further.
Does the Commercial Courts Act provides that if that stage is there, there need not be any statement of truths or admission of denial of documents? That is provides so. After conversion, the provisions has to be complied with. Does it say so that if the stage of the suit prior to transfer has reached the stage of evidence, there will be no statement of truths or denial of documents?
Not about, my lord, subject to correction, my lord. This is not about stage of at least stage of evidence. It's about the stage at which it has reached. From that, it has to be continued. Lordship would kindly consider that 15.4 case management hearings, section 15.4, which I had just placed. Yes. 15.4, the commercial division or commercial court as the case may be may hold case management hearings in respect of the transfer to the application in order to prescribe new directions or issue such further directions as may be necessary. Now, Lordship has seen order 11. Lordship was just considering order 11. Now, after that, Lordship would kindly consider order 15A.
Order
15A, 15 capital A.
CPC, sir?
It will be there, my lord, because in the schedule
Commercial.
it will be newly introduced.
Order 11.
Post amendment CPC, post commercial, post 2015, post 2018.
15A, yes.
Yes. Case management hearing. The court shall hold the first case management hearing not later than from the date of filing of affidavit of admission or denial of documents of all parties to the suit. In this case, does not. Now, orders to be passed in a case management hearing. In a case management hearing, after hearing the parties and once find that there are issues of fact and law, which require to be tried, the court may pass an order. Then A, B, C, D, all this is there. Then, my lordship would also consider 5. The court may, if necessary, also hold case management hearings anytime during the trial to issue appropriate orders and speedy disposal. If these are, my lord, 15.3 says, section 15.3 says that provisions of this act shall apply to those procedures that were not complete. Now, statement of truth is a really speaking, my lord, of formality that has to be done, that is there. But today, my lord, the stage of evidence, when my evidence is complete, their evidence, they have also proved documents. Now, my lord, whether anything is remaining, anything remains for admission and denial, that is the question. From what stage, if today lordship passes directions in a case management hearing, apropos lordship's authority under this sub-rule 5. Now, my lord, definitely, even if lordship passes directions under sub-rule 5, lordship would not surely direct for framing of issues as in 2A or because this has been done already. So this has to be, my lord, taken from the stage. This has to be, my lord, given a purposeful interpretation, taken from the stage where it's progressing. The witness was already in the box. Just because my learned friend, just because the defendant is not willing, if I may, because that's the term they is not able to, if I may so use, the word they have used in the application, able to proceed with the witness, does not mean the burden does not fall on me to do it de novo. They have decided to bring in a new witness. Absolutely. I can't stand in the way. I cannot stand in the way. But that's their burden. Just because now lordship would consider situation. If this new witness would have come in, if this original witness for the defendant would have continued, then surely, my lord, I wouldn't have been asked to do this because the witness is midway. Because the already is going on. Because this is not really, my lord, the purpose. Nobody would, I am sure, contend that the examination chief or crosses the deposition is going on. In the middle, the parties are being asked to deny or admit documents. That would be a different kind of prejudice.
Then 15.3 would have a proviso clause.
15.3.
Yes.
But 15.3
says that the
Yes.
provisions of the act shall apply to those procedures that were not complete at the time of transfer. Now there is a transfer, and wherein evidence of the defense witness was on dock. From that stage, you have to comply the orders.
Yes, but
It doesn't contain a proviso clause that provided that when the witness has been examined on behalf of the parties, these provisions need not apply.
Subject to correction, my lord, this
Because you are making a distinction
yes.
of a case where evidence has been complete. So there is no use of having a denial of documents, admission of documents. What purpose will serve? It will inure to delay of the proceedings. This is your submissions.
Lordship,
Because you have taken to case management. Case management deals with expeditious hearing, how to manage the case and expeditiously. Since evidence has started, what is the purpose?
Lordship would not take me on this. There are two caveats to this. I bow down, my lord. Lordship has perfectly summarized my argument. Two caveats. First is, I am not saying it's to anything as such to do with completion of evidence per se. I am only saying, as a matter of principle, matter of law, it is to be from. It might have been that the pleadings are only complete. From that stage is transferred. Then, my lord, it has to be from the framing of issues. Then, my lord, the entire thing would do. Now, my lord, it might have been that issues are framed, but the discovery inspection or the next is then, my lord, from that. All I am saying is, as a matter of principle, just because today, my lord, the defendant decides that it will bring in a new witness, the entire book cannot be rewritten. Because if the witnesses, because if the existing witness was already on dock, then, my lord, I would not have been asked to do this. If the witness had continued, then, my lord, because lordship would consider again kindly that rule 4 as to admission or denial is at the stage after inspection, discovery and inspection. If lordship kindly consider that once again. Order 11. Thank you. Order 11, lordship would kindly consider what is about. Lordship has found order 11? Yes. One is, rule 1 is disclosure and discovery of documents. Then rule 2 is discovery by interrogatories. 3 is inspection. 4 is admission and denial of documents. So this is all, my lord, before the witness action starts. That is the, my lord, usual. The only
No, I think 15.3 will apply in every case.
then, my lord, then may I, my lord, put it this way. If that is the case, my lord, then this part, that to those procedures that were not complete at the time
No.
of transfer.
Since it is, suppose as per section 2, the dispute is a commercial dispute. As per 15, it is transferred to the commercial division. 15 can be applied partly, there cannot be. The provisions, once a commercial suit number is given, that means the compliance of 15 has to be there.
Yes. Now, lordship would kindly
Now,
know.
we cannot interpret a fact that since it does not suit the plaintiff, see, even if the application is not filed, was it not the incumbent upon the plaintiff to regularize the suit by filing statement of truth? Why the defendant will indicate that this has not been done, so you do it.
Yes.
So once a commercial suit number is given, so it was the responsible plaintiff to approach the defendant and file those.
Lordship would kindly read 3 once, kindly consider subsection 3 of 15 once again.
Oh.
Where any suit or application, including an application under the Arbitration and Conciliation Act 1996, relating to a commercial dispute or specified values, shall stand transferred to a commercial division or commercial court. Lordship, correct me if I'm wrong, this means that this talks about a case where, apropos subsections 1 and subsection 2, it has already been transferred. It is shall stand transferred. Now, the legislature says when it shall stand transferred, the provisions of this act shall apply to those procedures that were not complete at the time of transfer. So first, legislature first part says first part that it talks about the suits which shall stand transferred because of whatever be the reason. 1, 2, it qualifies as a commercial suit. Then it says, once it stands transferred, those procedures shall apply which are not complete at the time of transfer. Now, my lord, I ask myself, which are the procedures which are not complete at the time of transfer? Witness action was going on. The entire thing was going on after that. Now, my lord, if the interpretation, which I bow down to that, the interpretation which my lord or probably my learned friend is also seeking to my lord advance, if that is the case, my lord, then this part, those procedures which are not complete, this, my lord, probably would be rendered odious. Then, my lord, in every suit, say, lordship would kindly consider the suit is at the stage of argument. At the stage of after trial, the suit has been transferred. Almost trial is over, the suit has been transferred. Even in that case, my lord, potentially, then the parties might be asked, my lord, to do this entire exercise. That, my lord, with greatest respect, cannot be intention of the legislature. Intention is to speedy trial. For that, in case management hearings, even today, lordship can pass directions. That is, I do not stand in the way, I cannot stand in the way that the box that has been already closed, the stage that has been already completed, whether, my lord, lordship would reopen that, whether the plaintiff can, or whoever it is, any of the parties can say, no, you reopen that. Because though very evidently, the stage of Order 11, Rule 4, that stage has passed. Because the witness action started. Now, affidavit of admission and denial, subject to correction by my learned friend, of course, by my learned friend, that is the stage only comes before witness action. And the consequence, if the parties do not do the consequences, follow all these penalties, that's there. That's statutorily prescribed. If that is the case, my lord, that stage comes when the witness...
No, sir. We cannot read the act which is not provided therein. This is the difficulty. If it says that the procedure as per Commercial Act has to be followed, then all the procedures has to be followed.
only
That
those
was
proceedings.
I was indicating that the legislature would have provided a proviso clause that if it stage is reached where evidence is being taken or the stage of argument, these procedures need not be followed. It could have been a
May I,
provision.
because I might be wrong. Lordship would kindly grant me tomorrow. I will just, because that was my understanding also. That is that has been
Obviously.
my understanding. So I might be wrong. So I will check up once again whether I can
Then
find.
again a question arises, if the defendant argues this point in argument, that since this has not been complied, what will be the consequence of the suit? Is the plaintiff entitled to have a decree as per under the Commercial Courts Act? That can also be argued by the defendant.
Yes. Now for that,
And
Lordship would kindly consider.
So you come back tomorrow, see the provisions, come back. Definitely.
Sure.
Madam, also you make your replies. Because he says that the evidence are admissible, so there cannot be expunging of the evidence. The weightage will be decided at the
I
time of
don't want to interrupt my learned friend, but
tomorrow.
tomorrow is not a commercial court day.
তাহলে কি করবো?
I don't have any objection to tomorrow. If your lordship
নিতে
takes it
পারবো?
up, I am.
হয়ে গেছে তো উনি just একটু indicate করুন।
But I will take some time to rebut what he has said.
And the decisions he has referred.
Yes.
Heard Mr. একটা line করুন। Heard Mr. So-and-so, learned advocate for the respondent. He seeks some, seeks some, yes.
Can it be next Wednesday? Because
Next Wednesday, I'll not be in Calcutta because circuit bench in Jalpaiguri.
Oh, in
So,
that event,
either in
I leave it to
month
your
of February or tomorrow.
No, tomorrow.
He seeks some accommodation to place his further arguments. Please this matter tomorrow. এটা আমাদের
May I? I just realized I should have pointed. May it be on Friday by any chance? Is it possible at all? If I ask myself, my lord. Instead of
তাহলে
tomorrow,
ফেব্রুয়ারিতে
just
দিন কভার
realize
করবেন
something.
আর পারা যাবে না ফ্রাইডেতে আমার তো সাইনিং গুলো থাকবে because
Well,
madam after he come back on in the month of February you do it because since he has
Leave
on
my
Friday I will
learned
not be
friend suit.
Huh?
I am not in a hurry.
okay,
If he wants to delay it, I can. I have.
ফেব্রুয়ারিতে কমার্শিয়াল ফার্স্ট ডেটা থাকছে ফেব্রুয়ারি
I apologize, my lord, but I just realized tomorrow.
এই তিনটে judgment কি তোর কাছে রাখবো?
Pita.
please this matter on 5th February এটা দাও
Macho.
Deeply.
5 number matter item number 3.
My lord, this is my application. Of 92 of 2006, I am the defendant number 2. But at the time of institution of the suit, no writ of summons has been served in the year 2006 or thereafter, my lord. In the year 2023, from the AB Bank of Maharashtra, the authorized representative of the Pubali Bank came to know that one suit has been instituted before the Honorable High Court Calcutta, which has been registered as suit number 92 of 2006. Thereafter, my lord, they came to this Honorable Court. They are the foreign bank. Pubali Bank Limited. Address is, my lord, Bangladesh. My lord, kindly takes up my application.
you are defendant number 2
Yes, my lord.
no writ of summons has been issued
No writ of summons has been issued.
who is for the plaintiff
Utsav Rice Mill Limited.
you have served
Yes, my lord. On last 2 occasions, they have not coming before this Honorable Court.
advocate on record service করেছে advocate on record no if the track consignment report of this an advocate on record has been intimated Utsav Strand Road defendant number 1 is also a Bangladesh
Yes.
Place the track consignment report. Affidavit of service filed on behalf of the applicant, defendant number 2, is taken on record. It is found that the track consignment report showing service has not been appended to the affidavit of service. Learned advocate on record for the applicant is directed to file press affidavit of service appending the track consignment report. Stop. Learned advocate on record for the applicant is also directed to serve copy of this application upon the advocate on record for the plaintiff. Who is advocate on record for the plaintiff? Please this matter. Serve and come back.
My lord, kindly give me a date.
Please this matter in the 12th February.
Regular bench matter. Item number 1 to 5.
Well, item number 1, my lord, my application, my lord. But this is an application, my lord.
Item number
1. My GA number 185 old number and GA number
No,
135 new number.
অঞ্জন বাবু এটা কোর্টটা ডাকলেন এটা একজন মোশন যেটা ওর একটা আছে তো
এটা তো আপনি যেটা last হলো যেটা এটা আগে হয়ে গেল এটা পাস মার্কস
এটা হচ্ছে ওই ম্যাডাম যেটা করছিলেন
হ্যাঁ
your application.
My application, this is an application, my lord, for confirmation of sale. So, my lord, if your lordship kindly hear me out first, my lord, so that I can place my application, my lord.
My lord, for the defendant number 3.
Number 316 accommodation, non-application by receiver.
Only the
Remain present. Where is the receiver? Who is representing?
So from
You are the receiver or you are?
on the last occasion, your lordship directed me to serve and intimate the learned receiver, my lord. present.
Sir. No. Okay. Yes.
This application is pending since 2018, my lord. And my lord, the application has already been served upon all the respondent, my lord, time and again, my lord. Specifically, my defendant number 3, my lord. It has been served.
3. You are 3. Who is 3?
3.
3 1 and 3 3. Yes.
No,
Substitution application again.
my lord, my learned friend is, my lord, let me place my application, my lord. My learned friend is asking for substitution, my lord. Because since my lord, learned receiver is here, my lord, he is taken care of all the years of the.
Okay.
You are the applicant.
I am the applicant of a highest
One.
bidder.
What is your status in the suit?
My status in the suit, my lord, I am the highest bidder because, my lord, there are some properties put for sale, my lord. I have applied for that. I have participated in the sale, my lord, and I have been decided, my lord, as a highest bidder. And thereafter, my lord, receiver filed his report, my lord, and thereafter they took the exception of the report, my lord, that has been dismissed.
Valuation and publication has been made.
My lord,
Valuation of the property, publication of the property for sale.
that is made.
That is made.
I am showing your lordship one by one, my lord.
Yes.
Let me allow, my lord, to take the case, my lord. Your lordship, my lord, a few property was
Okay.
put for sale, my lord.
Before starting, just let me ascertain what are the other applications. What is 2? Substitution. 3. These are your application. 2, 3, 5. Substitution. And 4. Yeah. Yes.
Well, in the year 2006, my lord, there was an order by virtue order of this honorable court. A few properties was put for sale, my lord.
Page number?
My lord, that is read my lord. I am showing you, lordship. Before placing, my lord, I will show each and every. My lord, before I'm placing the facts, my lord, I am just in a nutshell, my lord, placing the facts. I will show your lordship every document, my lord. Thereafter, my lord, my client applied for a participation in the sale, my lord. Thereafter, they made an application. If you co-sharers, my lord, made an application that is GA number 2775 of 2013, my lord. That is Annexure A, appearing at page 33 of my application, my lord. There are 2 volumes, my lord. বসো না ভাই, বসো।
এই অঞ্জন বাবু, এখানে অ্যাপ্লিকেশনটা 135 এখানে এসছে, এটা 185 দেখাচ্ছে। নতুন নাম্বার? আচ্ছা আচ্ছা, ঠিক আছে। Yes.
And again, they have applied for, my lord, for sale, put for sale of the few properties of the partition suit, my lord. That is, my lord, GA number 2775 of 2013, my lord. That is appearing at page 33 of my application. That is volume number 1. Thereafter, my lord, an order was passed in that application, my lord. And this honorable court was pleased to allow the co-sharers to put for sale, my lord. And receiver was directed to conduct the sale. Thereafter, my lord, a notice was published in the newspaper, my lord. That is, my lord, 18 January 2015, notice was published. Thereafter, my lord, according to fresh notice, my lord, that is, my lord, page 104, a fresh offer was made by the petitioner, my lord, in terms of the publication, my lord, notice, my lord. That is Annexure C, page 104 of my application, my lord. Thereafter, my lord, receiver called for a meeting. That is, my lord, Annexure D, page 106.
Yes.
Thereafter, my lord, petitioner, according to the direction of the learned receiver, my lord, petitioner put in, my lord, earnest money. Since I have been decided as a highest bidder of this particular property, my lord, that is appearing at page 112, Annexure E of my application. Thereafter, my lord, receiver filed its report. That is, my lord, page 113 of my application. My lord, on 30th June 2015, my lord, defendant number 3 took out an exception of that report. And an order is annexed in this application, my lord. I show lordship, my lord. That is, my lord, Annexure F, page 166. That is volume number 2. Defendant number 3, my lord, did not prefer any appeal from that order. Defendant number 2 preferred an appeal from that order.
What
That
is
is-
the order passed in 33?
My lord, I am showing lordship.
This is the first order.
This is the first order.
What is the order passed in?
I am showing a lordship, my lord. Kindly give me a moment, my lord. My lord, page 101, kindly lordship, come to 101. That is, my lord, passed by Honorable Justice Devanshu Bosak, 24th September 2014, my lord. Annexure B, page 101. May I place the order, my lord? The application is opposed to the opposed by the defendant number 3. The defendant number 3 relies upon a judgment and order of the Honorable Supreme Court dated February 26, 2013, where the Honorable Supreme Court had directed partition by metes and bounds in favor of defendant number 3 in respect of 9 properties involved in the suit. It is submitted on behalf of the defendant number 3 that similar directions should be passed so far as the immovable properties in Schedule F and H of the petition is concerned. It is submitted on behalf of the applicants that the Honorable Supreme Court directed keeping apart the share of the defendant number 3 in respect of the 9 immovable properties, since the development agreement was sought to be implemented. The direction of the Honorable Supreme Court should be read in such context. It is also submitted that the right of the defendant number 3 will crystallize upon her obtaining probate of the will for which she has applied. It is submitted on behalf of the defendant number 3 that she is already enjoying a probate for 1.9% of the property is concerned. For the balance, 9.58% appropriate proceedings are still pending and an administrator penalty has been appointed. I have heard the rival contention of the parties. The suit is pending since 1987, subsequent to its transfer to this honorable court. This suit is one for partition. Considering that there is no subsisting order requiring division of any of the immovable properties by metes and bounds, I find it appropriate to direct the receiver appointed to make further efforts to sell the immovable properties described in Schedule F and H by public auction, subject to the confirmation by the honorable court. The receiver will publish advertisement once in Statesman and once in Ajkal. The applicants will put in the cost for such advertisement at the first instance. The applicants will be entitled to reimbursement of the cost incurred for sale from the sale proceeds of the immovable properties concerned. GA number 2775 of 2013 is disposed of, no order as to cost. Thereafter, my lord, according to the direction of this honorable court, my lord, a notice was published. That is not with us, my lord. That should be recorded with the my lord, receiver, my lord. I have applied, my lord, in terms of the order of this honorable court, my lord. That is 23rd January 2015. Just next page, my lord, 104. This is my lord. This has reference to the publication notice dated 18 January 2015, made in Sunday Statesman and also made in Ajkal in the above referred matter. I have perused and gone through the said notification and have mentioned the meaning and contents thereof. Understood the meaning and contents. You are aware that on earlier occasion I had made an offer with regard to the property at premises number 63 and 67 Rakaldas Hatti Road, Kolkata 27, which was annexed to the above paper application. Pursuant to the order dated 24th September 2014, passed by this honorable court, Honorable Justice Devanshu Bosak, I renew my offer with an intention to purchase the said premises number 63 and 67 Rakaldas Hatti Road, Kolkata for a sum of rupees 12,50,000, which please consider. In view of the above, I humbly request you to get me informed as and when the sale of the above referred premises will be considered for sale and allow me to participate in the process of such sale. Thereafter, my lord, there is a minutes of the meeting, my lord. Receiver called for a meeting that is appearing at page 106, Annexure D, my lord. In this minutes, my lord, it is recorded by the learned receiver. Yes, that is 107, my lord. 107, my lord. At the top, my lord, that is just third column, my lord. Rakalda 63 Rakaldas Hatti Road and 67 Rakaldas Hatti Road. Panchanan Chakraborty, rupees 25 lakhs, 12.5 lakhs properties, my lord. Balance, my lord, that is
Just interject.
the highest offer.
Just interject. Now, all these are matters of record, my lord. Now, many of the parties have expired, my lord. Substitution applications are pending, my lord. Those are required to be heard out first, my lord, because those their heirs are required to be brought on record. These are all matters of record, my lord, old matters of record. But though their heirs are required to be substituted and brought on record, because a suit with dead persons cannot proceed. So their heirs are required to be brought on record.
My lord,
Those
may I?
applications number 2 to item
My
number
lord.
2 to 5. Yes, that those applications. He's a purchaser. He will.
My lord, may I make one submission?
that-
My learned
that-
friend is making such submissions since 2018, my
These
lord.
are
My lord, I
substitutions
am saying, my
applications.
lord, because Rani receiver has been appointed
Hmm.
and Rani receiver will take care of all the legal heirs, my lord, interest, because my lord, my application cannot be pending since, because
So,
there are
receiver
hundreds
is
of
only-
co-sharers.
Receiver is only for
Oh,
management and administration.
my
This
lord,
is not-
that
receiver
is why, my
my
lord,
learned
marriage.
Receiver is not for representing the parties, my lord. It's only
Suppose-
for
The honorable
only for the management.
substitution application for the
235. And on the last occasion when those substitutions application was taken up by my lord, your lordship was inquiring
whether all the parties have been served or not. The services upon the parties is required. My learned friends are of the view since
now is saying that he is not suffering.
Hmm.
He is already
Wait,
3A.
please. Now
He has
they
himself
they
as
were of the view.
My lord, he
Let my learned friend not interject me when I begin.
my lord, he is tall in the way, my lord. He cannot do the sale, my lord, because he is not suffering. He is already on record.
Not substitute. The party
Very well. Those who are not substituted, my learned receiver is here to take care of all the legal years, man. This is my suppose, my lord, kindly appreciate the position, my lord. My application is of 2018, my lord. 2018, my lord. I am applied, my lord, by virtue of an order of the court, my lord. It is not an order against a dead person, my lord, because already receiver has been appointed.
I don't know why they are
lord,
standing in the way of the
I am not standing in the way, my lord. I am not, because my client's age is more than 80 years old, my lord. All if he expired, my lord, then my applications will be frustrated. Yes.
He's
Other,
enjoying the
my lord,
property.
it cannot be, my lord.
Substitution
Kindly
applications are
appreciate
required
the
to be
position,
heard.
my lord. My application is pending since 2018. My learned friend is making such submission with an intention not to do the sale.
No.
Yes, otherwise he cannot make such,
Fine,
because
fine.
the
Take up
substitution
that.
application is not application.
Substitution application.
It is not his application. My learned friend's application is there.
So then
And
let them not place those substitution applications.
why not? It is a matter of record. Why,
Substitution
my lord,
applications
kindly
are
appreciate the situation, my lord.
consideration
Kindly
disposed
see
of
all the
here
orders
and
time and again,
there.
similar submission
just
was
now,
made.
my lord, I have
Only
one more fact, my lord.
defendant number 3.
My lord,
Only defendant number 3 is
kindly,
making such submission
kindly
only in the way of
cost
sale.
title ones. Take up the cost title ones. I came to know that the plaintiff number 1, this Arutiyadi herself has expired. Her heirs are required to be brought on.
My lord, my application is 2018. RTRD expired subsequently. I cannot, my lord, I am not the co-sharer.
Let them deny the fact that
I am not the
that these
co-sharers,
parties
my lord.
have not expired.
Kindly, my lord, appreciate my situation, my lord. I am made an
As an order
application,
in
my
a-
lord, by
most
virtue
of
of
the
order of
parties
this
are
honorable
dead.
court. They have not preferred this appeal. I will show you. Kindly, may I place my application
Those
first, my lord.
applications
Let my
are
learned
required to be
dispose it
heard-
of my lord.
heard.
If my learned friend is not, my lord, dispose it of my lord. Because, my lord,
First serve the copy to the parties.
my lord, my learned friend is
I don't.
3 times he has been served.
No,
3
I
times.
am to the other parties has to be served.
My learned friend should not taken care of inquiries
Why
of
a
other parties.
purchaser is saying all this? I don't know.
Yes, I am purchaser because
purchaser,
I have my
intending
right
purchaser
accrued.
is saying all
My
this.
right accrued.
Why
When
a
receiver
intending
accepted my
purchaser
offer, my
is
lord,
raising such a high
when
price, I don't
learned receiver accepted my offer and I have put in my earnest money, my lord, my right accrued. It is a concluded contract, my lord, subject to my yes, my lord. My learned receiver has asked me to put in my earnest money, my lord. I have put in earnest.
correction to take back their earnest money if they are in such a hurry, my lord. That's
No,
the
we are not such a. Definitely, we should be in hurry, my lord.
they were
I
given a
should,
liberty by this court.
I should
You take back
appreciate
your
my.
earnest money, you
No,
take back
it
your
cannot
money.
be.
Don't pressurize the court.
I am not pressurizing the court. I am placing my application. You are pressurizing the court to
Why?
go into other side. No, my learned friend's application is not pending.
Applications are required to be heard and disposed of.
My lord, kindly see, my lord, from
First.
the record. How many times
Substitutions have to
plate
be
has been
made.
amended, my lord,
But
because of substitution. And everything has been frustrated, my lord, because of
this.
this.
Huge estate parties are required to be brought on record once they die.
Kindly, my lord, appreciate my situation. I have applied, my lord, by virtue and order of this honorable court.
So
Receiver is appointed by virtue and order of this honorable court, and I am requested to put in money. I have honored that request and put in my earnest money.
Receiver is not the representative of all the parties. The heirs are legal heirs of the deceased parties are required to be brought on record.
Well, that is recorded in the order I just now placed, my lord. That is 2775, and they have not preferred any appeal. I'll show you.
Not less than 10 parties are dead in this suit, my lord. And the
Kindly,
plaintiff number 1 herself has expired.
Yes, that I have no knowledge, my lord, because I am the purchaser, my lord. Kindly see, my lord, my position, my lord.
Kindly see, my lord, substitution applications are pending to item number 2, 3, 5, 4. Those are required to be heard first, taken into consideration. Then the plaintiff number 1 has expired. She is also required.
In my lord,
If the parties are substituted, what will be the effect of this prayer made in item number 1 upon the legal heirs?
Their heirs will come and say.
But he says that he has already put in the earnest money as per order of the court.
That is on record, my lord.
Sale has to be concluded.
No, order of the court, my lord, that will, for that matter, I will file an opposition, my lord, to his application. I'll file an opposition to his
My
application.
lord, before allowing my learned friend, my lord, kindly see the record how many times opportunity is given to file
I will
objection, my lord.
file my
Kindly see, my lord.
opposition,
No, my
in a
lord,
short
it
time,
cannot
my
be.
lord.
It cannot
How
be.
can he see?
I'll say, my lord, lordship, kindly come to the application.
I will file an
Yes,
opposition to his application.
lordship, kindly come to the minutes
Whether
of the
this
meeting.
undervalue sale can
They
take
have
place or not, my
participated
lord,
in the sale,
I
my
will
lord. They have present in the
purchase-
minutes.
purchase
What is
a-
Why this,
My
all
lord.
this time you have not put in your opposition?
I will file, my lord. Can you give me a last
My lord,
opportunity? I have been
No, my lord.
substituted,
It
my lord.
cannot be, my lord. 2018, my lord. What my learned friend is making objection, show from the application, my
I
lord.
will file
He
my
doesn't have any
opposition, my lord.
obligation in his
Undervalue
possession right
sale,
now. He's
my
making
lord.
submission.
25 lakhs.
He
of
doesn't
property
have
and
that
I
obligation.
go-
My lord, my
I'll
application is
prove,
not
my
with
lord.
him, my lord.
Cannot go, my lord.
My application is not with him, my lord. Since, my lord, they have not carried the brief, my lord. It is served.
25 lakhs.
3 to
of
4
property
occasions.
at Alipo, 4
That
kata
is not
property.
your problem. That
Huh?
is the problem of learned receiver. At
I
that
can't
point of
make a
time, it
submission.
is a bid. It is a, yes, you have not
আর কোনো order book আছে এটা এই application?
time and again opportunity was given to file objection. No objections come from them, my learned friend. Only my learned friend is here to object. No other courtier is objecting to my application.
No, no. There are others, my lord. Let them.
My application, my lord.
Page number 160.
My page is like in this way, my lord. Kindly, my lord.
Yes.
I have analyzed also. Or should we kindly come to the one of the book.
My client, my lord.
He offered for both 60 and 67. Now, kindly come to the last one of the schedule. One enjoyed ultra private limited offer dated 16 offered 13 lakhs for kindly come to the more exit of this schedule. Observation of submitted demand draft dated also 1.5 lakhs. Enjoyed infra submitted a demand draft dated 1.5 lakhs. So this was part of the report which was filed before the audit report and is subject to the consideration of now, my lord, what I find 13 lakhs is nice. Both demand drafts are there with me. They're not in cash. That was the property was just not before then said that you will need to take back the instruments taken. So they did not take those instruments are like they can be evaluated by them. Number this number
Who is the highest bidder? You give a notice to Vijay Infra.
this is one first. You can give me he made an application for information of sale of all the properties on the basis of this. That application is not there. But, take all the properties, they are taken up together for substitution by my daughter. That is what I thought.
Then you have to give the application numbers.
I will write out from my report that was made by the defendant between.
Okay, you provide that. And as regards these two properties, 63 and 67, since Bijay Infra Private Limited has quoted the highest price, I think that company has to be notified whether they're interested to have the property. Along with those applications for confirmation of sale, this will also come up. Then the next person, his application can be considered. Otherwise, your honest money will be refunded.
After considering Vijay Infra.
Vijay.
And
Vijay has to be notified because they are not in the knowledge whether this has been confirmed or not. It's still there. That's right. You are for?
My GA is 143 of 2023. That is not before your lordships. In connection with EOS 32 of 1987.
I have asked the learned receiver to provide the numbers where the applications have been made for confirmation of sale, so that all the confirmation of sale applications can be taken up together. His application is also there.
With me or not, I will find out.
Okay.
I have served to
অঞ্জন বাবু উনি মিস্টার শর্মাটা প্রোভাইড করলে তাহলে এগুলোর সাথে ওটা দিয়ে দেবেন। Okay. Mr. Ramesh Sharma, learned receiver, appears in compliance to pursuant to order dated 6th January 2025. He submits that
I always support
he reports that as per the bids submitted by the parties in respect of the properties comprised within 63 Rakhal, what is this? Rakhal Addi, Rakhal Das Addi Road, 63 and 67 bolam? 63 and 67. One. Company, namely Bijay Infra Private Limited, has bid the highest. As far as this application is concerned, it is 63 and 67 of Rakhal Das.
My lord. My application is 63 and 63 Rakhal Das Addi Road.
Learned receiver is directed to serve a notice upon Bijay Infra Private Limited.
My lord, may I make one submission, my lord?
Intimating the next date of hearing and their intention with regard to the sale, with regard to completion of the sale. You just intimate the next date and whether they are intending to have the confirmation of sale. Huh? Sale
But
be
may I make
completed.
one request, my lord? My lord, may I make a humble
Annexing the
request, my
copy
lord?
of this order.
My lord, may I make a humble request? Your lordship recorded that the Bija, that company is the highest bid. I do not know, my lord. But since, my lord, your lordship,
Not know?
my lord, I do not know the at that point of time when the bid was made, my lord, at that point,
Volume 2 of your application is you have annexed the
yes,
what
that
is been
that
provided
the,
by the receiver.
yes, that is subsequent. At
So
that time,
12.5 and
because
13,
bid was
13 is
made,
the,
my lord, in a closed envelope, my lord. What is that company is bidding, my lord? That I do not have any knowledge, my lord, so that I can raise my bid. Kindly give me an opportunity, my lord. If they are coming, my lord, then I can make further bid, my lord. That should, my
no
lord.
way, sir. No way. The receiver has given a report wherein he has indicated that he has bid 13 lakhs, you have given 12.5. So that I have recorded. He also says that Vijay is the highest bid.
Yes. So if they coming, my lord, then I can match that bid again before your lordship.
Now you know that Vijay has given 13, so you will come up with 14.
No. Very well, my lord.
Is this the way?
5 kata property at
It is all
Alipur
left to the receiver. Receiver has given a report. He has reported that 13 is the highest bid. Now a notice will be given to him. If he intend to do that, then we will decide. Huh?
Grateful, lordship.
List this matter on at a date 18th February. The application, the other applications being 2 থেকে 5 of the neven will be taken up along with the GA 135 of 2018. What is the number? Confirmation of sales গুলো নিয়ে আসবে। Learned receiver is directed to provide the pending applications, provide the number of the pending applications to the court officer. Okay, provide that.
Grateful.
Substitution.
না ওগুলো সব একসাথে আসে
All will come together.
Substitution are to be made, otherwise this will, then they will argue that the for making a substitution is very long back.
When?
23 one. GL number 175.
দেখি তো একটা application দিক।
Plaintiff number 4 died. Okay, appear was sorry. Plaintiff number 4 died. 155. Reason.
Page number?
The cost title leadership died, my lord, and then your lordship kindly come to page 17, where I have annexed the death certificate of Mirashin. Page 17.
This Aruti Addu has died.
Aruti Addi died. Because all are the family members, so everybody knows.
she is required to be substituted
Petition আছে? Petition আছে?
জানতে পারলাম ইয়ার্স এর নামগুলো
Please tell me one thing. Item number 2, who is the plaintiff and what is her name?
Number 2, it says Mari Devre Kadi.
আরতি আরটি
Aruti Addi died, your lordship. Plaintiff number 1. There is no application so far.
she has expired just
Few days back.
recent
Who is Mira Sen is plaintiff number 4.
Plaintiff number 4.
First title of the plaintiff has to be thoroughly checked, madam. Certainly.
এটা কপি সার্ভিস করা হচ্ছে thrice.
Of the plaint.
কি কথা হচ্ছে?
নর্মালি জন্মেছিল।
হ্যাঁ?
জবেকার মামলায় জন্মেছিল।
হ্যাঁ?
জন্মে গেছিল।
আপনিও?
হ্যাঁ, আমি তো আরো আগে জন্মেছি। 17 ballot is the death certificate of Mira.
So who will re-verify the plaint?
Here was Puranjan Aunty was verifying the plaint.
How can he do it? He is a defendant.
Puranjan Aunty was died.
He has died.
Yes,
Who are the contesting plaintiffs then?
yes, your lordship.
Who are the contesting? Plaintiff is not pursuing the matter.
None is pursuing. I being the one of the parties.
Because they are dead, they are required to be substituted. That's the point which I took at the first instance. I indicated to my lord. Plaintiffs are required to be substituted.
How he's
I am the
substituted?
defendant.
How he has been substituted? Who has
Upon
re-verified the
service.
plaint? Who has re-verified his plaint? Which part?
The service.
He has been substituted. He himself has been substituted. His name 3A, 3B, your lordship can see. His name, of his name, who has re-verified the plaint?
Tell me who will re-verify the plaint?
Your lordship,
None of the plaintiffs are there on record.
your lordship, your lordship, there are so many persons. 4A, what, who will be the substituted?
No, as per your prayer in prayer D, you say that leave be granted to the plaintiff to re-verify. Who is that plaintiff?
Mitali Pal Chaudhary is alive, 9A1, Mitali Pal Chaudhary is plaintiff. He is present, alive. Page 2, 9A, Roman 1.
এই অঞ্জনবাবু এই পার্টিশন সুটে যেসব প্লেন্টিফ যারা নেই তাদেরকে কি ডিরেকশন দিয়ে আবার আনাতে হবে নাকি? রি-ভেরিফাই হবে কি করে?
Your lordship can also direct the
ওই দিনে রেখে দিন।
administrator and management of the trial. Yes.
একটু আপনি দেখে নিয়ে আমাকে জানবেন কোন প্লেন্টিফের ডিরেকশন দিতে হবে। রেখে দিন ওই দিনে লিস্ট করুন।
পেপার আনতে হবে, না হলে হবে না। পেপার নেই এখানে। এই পেপারটা মেইন ইউএসএ পেপার, সব অ্যাপ্লিকেশন গুলো রয়েছে। ইউএসএ পেপারটা
নেক্সট
number 6.
I'm opposing this application. I'm for the plaintiff number 1.
Your lordship, I am for the application. I'm praying for 1 week more time, your lordship, for filing my reply. Where a date has been fixed for filing this reply, your lordship. I am not.
The last occasion, your lordship,
I'm praying for more 1 week time, your lordship.
1 week না হলে তুমি বেশি করে নিয়ে নাও, বারে বারে আসা।
2 weeks টানা দিই, 2 weeks.
ও
Lordship, may kindly
So,
allow 2
London
weeks
advocate
time.
for the petitioner seeks extension of time to file reply to the affidavit in opposition filed by the respondent. Let such reply be filed within a week. List this matter in the
If your lordship may kindly allow 2 weeks, then it will be very.
2 weeks. List this matter. কবে যাচ্ছে? Monthly list of February.
much. আপনার একটা ফাইল আছে, আপনার ফাইল। Number 7.
7 and 8 are both. I am appearing for the plaintiff
Your
in both the
Lordship,
matter.
item number 7 and 8, Mr. Ashit Kumar Varun Raut is appearing in this matter, Your Lordship. I'm praying for not this week, Your Lordship.
देखिए जिन record का
But then in one index, let us come up in the month list of February because the week thereafter, my lord, after the next week, my lord, I have some personal difficulty. I won't be here.
your monthly list on the prayer of learned advocate for the petitioner.
No, not for the petition, but
Will
I am for
happen
the
in the
plaintiff. I am not praying for it actually.
Respondent,
They are
GA4, we have
the
in
prayer
7,
of
we
learned
have,
advocate for the
respondent 4 and 5 and 6.
respondents.
respondent in which application?
GA4, Your Lordship. GA4 of 2019, we are for the respondent number 5 and 6.
देखिए item number কত চলছিল 8 তো item number 8 is GA5
GA5 is item number 8.
हाँ
There we are the applicant.
and GA4
GA4, we are the respondent number 5 and 6.
Is my application, 5 is their application.
Yes.
But originally we are the plaintiffs, they are the defendants.
Miss Fanso learned advocate appearing for the defendant seeks accommodation.
Published.
Monthly list of February.
Grateful to Lordship. 7 and 8 same.
Accept.
Accept.
Item number 9. Item number 9, I am for the petitioner. Your Lordship would remember this is that matter wherein by an order of 7th of April 2022, a special referee was appointed by the coordinate bench of this honorable court, wherein he has filed a report before this honorable court stating that the state of West Bengal is entitled to make payment of sum of rupees 20 lakhs and odd. Your Lordship, on the last 2 occasions, the state was not represented. We were being directed by your Lordship to give them a notice and we issued them a notice. Thereafter, on the last occasion, time was prayed by the junior of Mr. Siddiqui that your Lordship directed him to be present on the next date. Otherwise, it is recorded in your Lordship's order that the matter will be moved in absence of the state, your Lordship. But again, today, nobody is representing the state. And state has also filed an appeal against the order by which the special referee was appointed. But the state has participated in the proceedings, has filed, contested the proceedings, and thereafter the special referee has been pleased to pass an order. But they have not effectively, from the month of June 2024, they have not proceeded with the appeal. It's pending before this honorable court. And also before your Lordship.
Is there any order of stay in the appeal? No.
No stay. They have filed the application for condonation of delay under section 5. But that too, the Honorable Division Bench was not satisfied. Accordingly, they were directed to file a supplementary affidavit to explain the delay because the proper delay was not explained. They have filed the supplementary affidavit, but after that, they have kept it pending and not even proceeded with the appeal. For the last 8 to 9 months, the appeal is lying pending before this honorable court. And your Lordship is hearing this matter for at least 4 occasions, and only the last occasion after 2 times service, they appeared and prayed for time on behalf of Mr. Siddiqui.
Okay. Let us hear this matter. What is this matter?
Your Lordship, what has happened, your Lordship, there was a flat at Robindo Soroni. That flat was initially the accusation was taken place by the state of West Bengal. Thereafter, de-requisition was taken place. Thereafter, handing over possession was given to me. So in my writ petition, I have prayed the following prayers, your lordship. If your lordship would come to page number 44. There was an order passed by the land reforms officer, your lordship. He was directed to ascertain the amount of occupational charges which was to be paid by the state of West Bengal for the period in which state was in occupation of the flat in question, your lordship. That order, if your lordship would come to volume number, may I place that order first? Volume number 5, your lordship. Volume number 3, your lordship.
Volume 3.
Page 2, volume 3, page 283, annexer P7. Your order starts at page 284, your lordship. May I place the order?
284.
284, your lordship. Order of 4th of September 2018, your lordship. May I place the order, your lordship? Please, Sanjay Kumar Bajoria, who is the petitioner in the instant case, submitted a letter of 29th August 2018 to this office on 29th August 2019, enclosing an order of dated 23rd August 2018 passed by the Honorable Justice Tapobrata Chakraborty, High Court, Calcutta in WP number 52 of 2018. The matter involves premises number 255A, Robindo Saroni, Kolkata, which was requisitioned by this office by order number so-and-so, dated 28th October 1970 under West Bengal Requisition and Control Act 1947. The said requisitioned portion of the subject premises, that is the flat on northeastern side of first floor, was re-requisitioned by so-and-so, dated 30th of January 2003. But the possession thereof was finally restored in favor of the petitioner on 30th July of 2009, your lordship. The grievance of the petitioner is that the state authorities have not paid the outstanding rent compensation and mean profit of the said flat. The Honorable Justice Tapobrata Chakraborty has directed the respondent number 2, being the first land acquisition collector, Kolkata, to consider the petitioner's claim upon granting an opportunity of hearing to the petitioner by issuing notice within 2 weeks from date of communication of the order, and pass a reasoned order in accordance with law and communicate the same to the petitioner within a period of 4 weeks from the date of hearing. In WP number 52 of 2018, the petitioner prayed before the Honorable Court a direction commanding the respondents to pay a sum of rupees 1,03,98,290 on account of areas of enhanced part of rent compensation from November 1973 till February 1992 on determination of enhanced rent compensation as per law. Areas dues of enhanced rent compensation as per law from March 92 up to the date of de-requisition, order dated 30th of January 2003, interest on delayed payment, D, occupier's share of municipal tax enhanced by Kolkata Municipal Corporation, E, other cost, F, mean profit, G, interest solemn, H, cost and others. This Honorable Court was directed to dispose of the issue relating to title determination of the above premises, which was pending before the office of the first LA Collector, Kolkata. Considering the above facts and to comply with the direction of Honorable Court, Calcutta, the instant miss case is initiated. Your Lordship, then your Lordship will find some of the dates. If your Lordship would come to page number 287, the main order, your Lordship, of 31st of October. The main order, your Lordship will come to page 289. 289 and an order starts, but mainly 8th of April to page number 290, your Lordship. 8th of April 2019. This is the last order which is under challenge, your Lordship. Page 290. May I place the order? The matter is taken up for passing order as per the direction of the Honorable High Court, Calcutta. Two issues are involved in this matter. A, who is or are the present claimant of the rent compensation stroke mean profit in respect of premises numbers 255A Robindo Saroni. B, what is the quantum of rent compensation stroke mean profit payable to the petitioner as per government rules and orders. So far as point number A is concerned, from the available records and after hearing all the parties, I did not find anything that suggests the petitioner is not the sole owner of the property. The petitioner also submitted the assessment slip of the Kolkata Municipal Corporation regarding premises number 255A Robindo Saroni, wherefrom it is evident that the name of Sri Bajoria is already registered in the assessment roll of the corporation against the said premises. Hence, it is logically accepted that the petitioner is entitled to entire amount of the outstanding requisition compensation and mean profit. However, the onus lies upon the petitioner to make payment to the claimants if any legitimate claim of any of the successors of the original landowner of the instant premises arise out in future due to misrepresentation or suppression of facts, if any, by the present petitioner. So far as item number B is concerned, claim of the petitioner were considered with relation to admissibility thereof as per government orders in force. It is found from the office record that the owner of the premises of so and so prayed for revision of rent compensation on 1st of November 1988 and on subsequent dates. However, rent was not increased despite his repeated prayers. The landowner received rent at the rate of rupees 335 per month, inclusive of all of cost of repairs and taxes up to 28th of February 1992. As per existing government orders, the landowner is entitled to periodical revision of rent in every 5 years, especially in the face of his prayer seeking increase in rent. As per provision of statute, the period for calculation of occupation charge stroke mean profit should be counted since the completion of 25 years of requisition, here in this case on and from 20th of October 1995. The mean profit should be determined on the basis of reasonable rent of the premise in question to be arrived at by comparing rates of premises which are nearest its location as well as time zone preferably. Considering all these aspects, a fresh calculation on an area of 640 square feet requisitioned by the state has been made, as the landowner prayed for increase in rent only on 1st of November 1988. A 30% increase has been allowed for the preceding 15 years as per approval of Land and Land Reforms Department, and the amount payable comes to rupees 4,05,924. The details of entitlements and amount payable thereunder have been authenticated and approved by the department. With this, the instant case is disposed of. Now, an amount was directed to be given by this order, Your Lordship. Thereafter, we have challenged this order and have filed the instant writ petition because the calculation is expressly wrong. We have stated in the writ petition it should not be that. In fact, we have pleaded in our writ petition. If Your Lordship would come to paragraph number 24 of your paragraph number 26, page number 17 of Your Lordship's list, Your Lordship. The petitioner submitted that he is entitled to total sum of rupees so and so on account of the aforesaid as per the following particulars. I have given all the details how the payment is to be made by way of the particulars, Your Lordship. And claiming a sum of rupees 1,03,98,290, Your Lordship. If Your Lordship would come to paragraph 27 in the writ petition, the petitioner submitted that admittedly is entitled to receive rupees 5,23,400 as and by way of total occupational charges for the subject flat at a rupees 4 per square feet per month on the period of 13 years and 8.5 months, starting from 18th October 1995 till 3rd of July 2009, as per the respondent's own calculation. Your Lordship, the order which have passed by this Honorable Justice Dopobroto Chakraborty, by which the land acquisition collector has passed the order, the same calculation has not been considered by the land acquisition collector, and he has only stated that 4,05,000 is payable. After filing of the writ petition,
that amount has been paid by the state after deducting the TDS at source, your lordship.
Which amount? 4 lakhs.
These 4 lakhs 5,000 that has been paid by the state authority. But the other amount which has not been paid, by an order of 7th April 2022, the Honorable Justice Shubhra Ghosh was pleased to appoint a special referee and was pleased to pass an order in terms of prayer G of the writ petition. If your lordship would come to page number 47 of your lordship's brief, your lordship, the prayer is there. Prayer G. Page 47 of the writ petition. May I place, your lordship? A fit and proper person be appointed as special referee, special officer stroke special referee to discharge the obligation of the respondent number 2 arising of the order dated August 23rd, 2018, passed by the Honorable Justice Tapobrata Chakraborty in WP number so and so, upon giving the parties an opportunity of hearing and thereupon to file his report dealing with all the claims made by the petitioner and determining the quantum of rent, compensation, mean profit and other charges as directed by the order so and so. The special referee held proceeding and the state respondent participated in the proceedings. Minutes have been recorded and ultimately the special referee has been pleased to pass an order and pass an order which has been filed before your lordship by the special referee. Your lordship, if your lordship will come to the report of the special referee of 29th of February 2024, I think that has been given to alada kore ei thakbe. দেখেন স্পেশাল রেফারি ওই কাগজ জমা করেছিল ওর মধ্যে রিপোর্টটা থাকবে 29th of
report,
হ্যাঁ হ্যাঁ ভ্যালুয়েশন এইরকম দেখুন না সুভাষিস সেনগুপ্ত না ভ্যালুয়েশন রিপোর্ট না দেখো রিপোর্ট অফ সুভাষিস সেন অ্যাডভোকেট লার্নেড স্পেশাল রেফারি অরিজিনালি থাকে এইটাই when the special referee was appointed by this honorable court, your lordship, then he took proceedings of the matter and several sittings were held in which the state was participated and ultimately he made his conclusion. If your lordship would come to page number 28 of the report, your lordship.
Yes.
Conclusion. In view of the above mentioned observation, the special referee has determined the rent for the period 28th October 1975 till 27th October 1995 and the occupational charges stroke mean profit dated from 28th October 95 till 2nd July 2009 in respect of the flat at measuring 800 square feet in the following manner. Now he has calculated the rent from 75 to 95, which comes around 89,829. Thereafter, he has calculated, your lordship would come to next page, calculated the occupational charges from 95 till 2009, which comes to around 20,15,960. Thereafter, he has stated, during the argument, the learned advocate for the claimant has not disputed regarding the receipt of sum of rupees 65,660 on account of rent from the respondent, and therefore the said amount is liable to be adjusted with the final outstanding. As per the above mentioned determination of rent and occupational charges stroke mean profit, the claimant is entitled for sum of rupees 20,40,086 in the following manner. Then he has calculated outstanding rent, occupational mean profit and made the less payment of advance made and accordingly 20,40,000. Then he has also made the reference of making payment of interest at the rate of 8% in favor of the claimant from the date of accrual of the dues till the date of payment.
So this amount, 20 lakhs, this odd amount along with 8% interest
is liable to be paid by the state to the petitioner, your lordship. This report was also handed over to the learned advocate for the state of West Bengal on 29th of February 2024, your lordship. Now, after receiving of the said report, they have filed an appeal before this honorable court challenging the initial order passed by the Honorable Justice Shubhra Ghosh that the order passed in terms of prayer G of the writ petition. They have challenged that order. And lordship, as I have told you, lordship, they have not proceeded with the appeal after, in spite of filing that section 5 and a supplementary affidavit in section 5, which is pending since June 2024. Your lordship, I am led by Mr. Banerjee, your lordship.
Are basically the facts. Now, we have given the state, my lord, this honorable court as well as the petitioners, because we are conscious of the fact that the state will, it will ultimately may amount to certain adverse payment of money, adverse civil consequences on the state. Every opportunity has been given, my lord. The report has been given to date. There is no exception to the report of the special officer. There is no pleading on record which can purport to be an exception. The state, despite 3 or 4 opportunities or notices given, did not appear. If your lordship recalls, on the previous occasion, it was my lord's desire that Mr. Siddiqui's junior inform Mr. Siddiqui that on the next day a matter will be taken up. That day, Mr. Siddiqui's junior appeared. Thereafter, on the next day, neither his junior was present nor he was present. Today is the day thereafter. In the meantime, my lord, the special referee is an advocate of this honorable court. The special referee has the acumen to come to a conclusion. He's done so on the basis of materials on record in a adversarial manner, not in a inquisitorial manner. He has heard both the parties. There also, up to a certain extent, the state participated through counsel. Thereafter, my lord, the state really debunked and came up. Special referee has gone into the entirety. Now, my lord, the initial compensation that was my lord, awarded to me was 4 lakhs and odd. Special referee says it should be 20 lakhs. I have taken the 4 lakhs without prejudice by an interim order of this honorable court, because that is the least amount that could have been given. That is the interim order of this honorable court. The remaining amount from that 20, if your lordship deducts the 4, that will be the principal with whatever interest the special referee bears. State is
In the
clearly
report,
not.
the respondents are the state.
Yes. One is the state.
You are the claimant.
Yes. And they are not clearly interested, clearly not interested. They filed.
They have not adduced any evidence on their behalf.
If your lordship sees there, they have cross-examined our witness, but
they have argued the matter.
And they have argued the matter. Participated in the proceeding, argued it full tilt. Now, my lord, whatever manner of fair play was required, my lord, it has been done and done and done again.
This is all. The writ petition can be disposed of.
It can be disposed of. Your lordship can, if your lordship accepts the valuation report and then directs that the balance of the principal along with interest is to be paid, and sets aside, the order, my lord, which we challenged in the writ, which only gave us only 4 lakhs. So it's my lord, prayer F can, interim order can, final order. These, my lords, prayer A. Prayer A, if your lordship can set aside, if your lordship is pleased, my lord, with your with the materials before your lordship. And prayer C is also the same thing, setting aside that order of 4 lakhs, confirming 20 lakhs and telling the state to give us the difference between that 20 and 4, along with applicable interest as collected, as my lord, calculated by the special referee.
Okay. This writ petition has been filed.
Your lordship, kindly, my lord, my senior is there to assist.
Yes,
Your
Article 226 of the Constitution of India, seeking for cancellation, rescission, and or revocation of the order dated 8th April 2019, passed by first LA collector. First land acquisition collector, Kolkata, being respondent number 2. The despite notice, none appears on behalf of the state respondents. Next slide. The petitioner's case in brief is that a flat The petitioner, along with his family members, are the co-owners in respect of property comprised within premises number 255 capital A and 255 capital B, Ravindra Sharoni, Kolkata 7407 since 1969. A flat situated on the northeastern side of the first floor of premises number, measuring premises number cartoon, measuring an area of 800 square feet more or less within premises number 255 capital A Ravindra Sharoni, Kolkata 2 was requisition. For the purpose of Home Police Department, and the possession of the said flat was duly taken from the co-owners of the said premises. The monthly rent compensation of the said flat was fixed at rupees 335 per month. Under memo number 53 capital P1 slash P4 slash R slash 3 slash 71 dated 11 January 1974. By order number 36316 dash registration REGN REGN slash RC dash 6 slash 2001 dated 30th January 2003. The said flat was de-requisitioned by Deputy Secretary, Land and Land Revenue Department, Requisition Branch, respondent number 5, and vacant possession of the said flat was restored to the co-owners, including the petitioner herein. Since the vacant possession of the flat was not handed over, a writ petition was filed being WP number 159 of 2005, wherein a direction was issued for restoration of the possession of the said flat. Pursuant thereto, finally, the vacant possession of the said flat was restored to the petitioner under restoration certificate dated 3rd July 2009. By later under memo number 90 within bracket 4-LA dated 5th February 2010. The respondent number 1 requested the petitioner and other co-owners to submit rent compensation bill in triplicate. In reply to the aforesaid letter on 24th February 2010, the petitioner paid for arrears of enhanced part of rent compensation from November 1973 to February 1992. On finalization of enhanced rent compensation as per law. Arrears dues of enhanced rent compensation as per law from March 1992 up to the date of de-requisition order on 30th January 2003, comma, interest on delayed payment of rent compensation up to January 2003 till date of payment, and occupier's share of municipal tax. Since payment was not made, since payment in respect of rent compensation was not made, a letter of reminder was issued on 10th January 2013 to respond number 2. Ultimately, the petitioner was constrained to file a writ petition being WP number 52 of 2018 for realization of arrears of enhanced part of rent compensation, comma, interest on delayed payment and occupier's share. The said writ petition was disposed of, directing respondent number 2, First Land Acquisition Collector, Kolkata, to issue a fresh notice granting opportunity of hearing to the petitioner and pass a reasoned order. Pursuant to such direction, the respondent number 2 what is that date of the order? The respondent number 2
Date of the order,
8th April, no?
2019.
8th April 19.
April 19, page 290.
8th April 2019. This order is at page number?
Page 290. 290 of volume 3.
Volume 3 টা আছে already. Volume 3 বলছে? এইটা, oh sorry. Calculating the amount payable to the petitioner to the tune of rupees 4,05,924. Being aggrieved by such order, the petitioner has preferred the present writ petition. Justice Ghosh's order. Where is the order passed by Justice Ghosh?
Seventh of April 22.
By order dated 7th April 2022, after hearing the learned advocates for the petitioner as well as state respondents, an order was passed appointing in terms of prayer G of the petition, appointing
Only one thing, Your Lordship, the name which was appointed by this order, that has been changed
by a subsequent order.
by subsequent order of 5th of May.
Okay, not required. নাম দিতে হবে না. Appointing a special officer / special referee to assess the outstanding rent compensation, mean profit and other charges in presence of both parties or their authorized representatives upon giving reasonable opportunity of hearing to both the parties. একটা কাজ এটা বলুন তো এখানে আমার নামটা এসে ঠিক আছে who shall be at liberty করুন who shall be at liberty to place all relevant documents before the special referee for consideration. Paragraph. In compliance to the aforesaid order passed by this court, the special referee / special officer filed its report as per the aforesaid report. The total outstanding dues towards occupational charges slash mean profit is calculated at rupees 20,40,086. What is the amount received?
Amount received is
It is informed by the learned advocate representing the petitioner that the petitioner has already received the amount calculated by respondent number 2. That amount
after deducting TDS, I have received the amount 3 lakhs something. Your Lordship,
has
after
received.
deduction of TDS, I have received that amount.
The amount which is to be received by the order of this court, what will be the amount?
4 lakh. As per 8th April 2019 order, the amount which was supposed to be paid, 4,05,924, that has been paid.
4,95. Please give the amount.
4,05,924.
924 has been received. This amount has been received.
Received after deduction of TDS.
After deduction of TDS. Learned advocate for the petitioner submits that the petitioner is entitled to the balance amount of rupees 20,40,086 less 4 lakhs. Okay. The amount comes to
amount will come to 20. So 40,086 minus 4.
According the petitioner is entitled to an amount of rupees.
And the amount of rupees 16,34,162.
Together with interest at the rate of 8% per annum from the date of which date this will be?
From the date of accrual, Your Lordship, of the dues, because the rent has been last paid till 95 and occupational charges till 2009 has been calculated.
From the date of accrual of the dues till the date of the payment.
Date of payment.
Actual payment.
Actual payment.
It is Karakore, it is placed on record that there is no exception to the report of the special referee, filed by the state respondents. Learned advocate for the petitioner informs the court that an appeal has been preferred by the state respondents against the order passed by this court on 7th April 2022. However, there is no order of stay passed by the appellate court. According to Karakore, the writ petition is disposed of directing the state respondent who will pay this amount. Directing respondent number 2.
Respondent number 2, the land acquisition.
Writing respondent number 2, land acquisition, first land acquisition collector, Kolkata, to disburse the amount, or amount of 16, together with interest, in favor of the petitioner together with interest কথা বললাম, together with interest যা ওখানে আছে, together with 8% from date of accrual যেটা বললাম ওটা ওখানে পুট করবে within a period of
8 weeks, I think.
2 months. Within a period of 2 months. Learned advocate for the petitioner directed communicate this order to respondent number 2. All connected applications, if any, stands disposed of. Interim order stands vacated.
I apologize to your lordship. The item number 19 of your lordship's monthly list. Only a procedural order was required, my lord. In that matter, there was a receiver. The receiver has 4 crores in his bank account. Now I'm the defendant in the suit, my lord. The plaintiff, my lord, I've served the plaintiff.
Tomorrow we'll see in the monthly list how it goes. Not now. এই নোটিশটাও রাখুন। Sure. Thank you.
Grateful.
My lord, I mentioned the one matter for Kamabaji listed motion, 2018 matters, my
Motion
motion.
of 2018
18.
group.
Group land matter, my lord, group one.
देखो क्या है? Motion field paper. This was never moved. It was never moved.
Moved.
Hmm?
But dismissed for default, thereafter file an application for restoration that was allowed 2023, my lord. Thereafter mentioned, my lord.
So why under motion? The application is. What is the can
Application
application?
is allowed, my lord.
Application allowed.
Allowed, my
Who is for the state?
Mr. Something I
Give a notice and then mention.
I will
Give a notice. Dr. Lisa.
Madam, item number 7, Mr. Shoktilaal Mukherjee, senior advocate, is appearing in this matter, my lord. He's leading me. But then this matter, my lord, the state wants to file a report, my lord.
Let me call the list. Don't mention. Let me call.
All right.
Number 1.
One.
It's my application, my lord, for restoration, my lord. My learned friend will reply, my lord. On the last occasion, we concluded our.
Yes, my lord. Mr. Rupak Ghosh was leading me. My lordship will recall, Mr. They will reply.
এই জাজমেন্ট গুলোর বই তো কোথায়? নোট নিয়েছিলাম, জাজমেন্টস গুলো কোথায়? জাজমেন্ট গুলো কবে কোথায়? হুম, ঠিক আছে। Yes.
For want of
Hmm.
for want of appearance, prosecution, or for failure to pay cost, service to process, or to furnish security of cost. My lord, in and 137, my lord, that is 137, my lord. Any other application for which no period of limitation is provided elsewhere in this division. 3 years. My learned friend, my lord, I oppose that he filed one application, my lord, without Section 5 application. My lord. He relied on a judgment, my lord. That is, if your lordship, next page, my lord, paragraph 4 of first judgment, my lord, that is 2005 2 CHN 642, my lord. He relied on 2 judgment, my lord. That is, my lord, that is 4, my lord, paragraph 4 I did, my lord. On 20th April 2004, the learned advocate on record, the writ petitioner respondent, forwarded a copy of the judgment and order dated 26 March 2004 to the bank for compliance. The same was duly received by the appellant bank on the same date. Even the general manager of the bank was served with the copy of the order under registered cover of 23rd April 2004. On 20th June 2000, since the time to comply the direction contained in the order dated 26 March expired, notice was sent to behalf of the writ petitioner to the chairman managing director to the bank demanding rupee jato. It was mentioned in the said notice that an application for contempt would be filed. The said notice was duly received by the applicant bank in the Ato, and on 5th 6th July, the bank filed 2 applications before the learned single judge, one for recalling and or modification. One for recalling and or modification of the judgment
an order dated 26 March 2005 and the order for condonation of delay in making such application. My lord, in his modification and that is all the things, my lord, in the according to the provision of the 151 CPC. According to the provision 151, if anyone wanted to modify modification or my lord anything else, my lord, then my lord it was under the CPC, my lord, it is 151 rule 151 CPC, my lord section. And my lord, next paragraph, that is the application for condoning the delay in filing the application for recalling the judgment and order dated 26 March. The application for condoning the delay in filing an application for recalling the judgment and order dated in it were taken up for hearing 5th December. In this matter, my lord, my contention, what is my contention? My contention, he must file an application for condonation section 5 application. And in this judgment, my lord, also there is a section 5 application is there, my lord. That is paragraph 6 is there, my lord, section 5 is application. And given condoning the delay and accordingly dismissed. And my lord, various submission, after considering various submission made on behalf of the respective parties, the learned single judge was not satisfied with the explanation given for condoning the delay and accordingly dismissed the said application. Consequent upon such dismissal, the application for recalling and or modification of the order and stood dismissed. And my lord, that was dismissed. After dismissal, my lord, they filed one appeal, my lord, according to that, my lord, that is and my lord, paragraph, my learned friend, my lord, relied on paragraph 8. That is when the application regarding the prayer made for recalling the judgment and order in the writ application was taken up for consideration, query was put up to the learned counsel as to the period of limitation which would be applicable in making such an application. In answer to our query, Mr. Bimal Chatterjee, learned advocate appearing on behalf of the appellant bank, submitted that although arguments had been advanced before the learned single judge on the supposition of the Article 122 of the Limitation Act would have application to such an application. Upon further examination, it would appear that Article 122 would have no application to the facts of the case. And after that, for review, Mr. Chatterjee also urged that although it could not be urged that Article 123 may have application, strictly speaking, the same would not be applicable in the instant case, since the article makes reference to a degree in a suit or expression of degree, has been defined in section 2.2 of the Code of Civil Procedure to mean the formal expression of an adjudication, which so far as regards the court expressing it conclusive determines the right of parties with regard to or any one of the controversy in the suit and may be either preliminary or final. Bimal Chatterjee submitted since instant. Now, my lord, in paragraph 3, my lord, 13. That is, I may not want to. That is, my lord, Mr. Ajoy Chatterjee, learned advocate appearing on behalf of the writ petitioner respondent, strongly opposes the stand taken by Mr. Chatterjee, Mr. Bimal Chatterjee, according to Mr. Ajoy Chatterjee, point which has been urged before the appeal court had been urged before the learned single judge, and in the event, even on merits, the application for condoning the delay could not have been allowed by the learned single judge. Mr. Ajoy Chatterjee pointed out that due to the sheer negligence and or laches, the appellant bank had failed to file the affidavit in opposition or to take steps in the matter when the writ application came up for final hearing. Despite notice having been given that the matter was appearing in the warning list of the learned single judge, Mr. Chatterjee also urged that despite having notice to the judgment and order dated of the learned single judge, at least 20th April 2004, the bank had acted negligently in not taking expeditious steps in filing this application for recalling the final judgment in the writ application. Apart from the above, Mr. Ajoy Chatterjee also urged that while Article 122 of the Limitation Act 1963 would possibly have no application to the facts involved in the Article 123 squarely applies having regard to the provision of the writ rules framed by this court in dealing with matters under Article 226 of the Constitution. Mr. Chatterjee urged that Rule 53 of the rules make it very clear that save and accept as provided by the rules and subject thereto the provision of the Code of Civil Procedure in regards of suits shall be followed. As, my lord, as far as made application, that is Code of Civil Procedure in regard to suits shall be followed. As far as it can be made applicable in all the proceeding under Article 226 of the Constitution of India, Mr. Ajay Chatterjee drew our attention to the wording of Article 123 of the Limitation Act, which inter provides that to set aside a degree past expertise or to rehear an appeal, degree or hard expertise, the period of limitation is 30 days from the date of the degree which the summons had been served, where the summons or notice had not been served when the applicant first had knowledge of the degree. Mr. Rajiji contended that since the provision of Civil Procedure Code have been made applicable to the writ matters, so far as practicable, the expression degree as defined in the Civil Procedure Code under Section 2, subsection 2 should also be included to give proper meaning to the provisions of the writ rule. In our words, according to Mr. Ajay Chatterjee, Rule 53 of the rules under Article 226 of the Constitution and also the provision of Article 123 of the Limitation Act must be read together in order to give a harmonious meaning to the provision of both the rules and the procedure to be followed in matter relating to Article 226 of the Constitution, particularly since no provision at all had been made in the rules for recalling orders or disposing the writ petition finally. Mr. Chatterjee submitted that in view of the matter, the learned single judge has rightly dismissed the application for condonation of delay which had been made within the period of the limitation as prescribed under Article 123 of the 1963 Act, and no interference was called for in respect thereto. On a careful consideration of the submission made on behalf of the respective parties, it is quite clear that Section Rule 53 of the Rules of the High Court under Article 226 of the Constitution makes the Civil Procedure Code, wherever possible, applicable to proceedings under Article 226 of the Constitution, but the same does not ipso facto bring within the ambit of the law limitation with regard to suits. Both Article 122 and 23 of the Limitation Act clearly refer the suits where the Article 137, which is the residuary provision, deals with the application of all kinds for which no specific provision has been made. Apart from the above, Rule 53 of the rules, while indicating that the provision of the Code of Civil Procedure in respect of the suit shall be allowed as far as made practicable in all proceeding under Article 226, indicates the rules may not deem to limit or otherwise affect the inherent power of the court to make, that is the inherent power of the court to make such orders as may be necessary for the ends of justice to prevent abuse of the process. In our view, said expression recognizes the inherent power of the author to deal with matters applicable to proceeding under Article 226 of the Constitution, whereof the view Article 137, which deals with the application of all kinds, would have application in this matter. It may be pertinent to produce language of Article 130 Limitation Act, which reads as follows. Now, ultimately, my lord, that in the appeal was, my lord, subsequently allowed. My lord, his moot question is whether Section 5 should be filed or not, my lord. And if Section 5 filed, my lord, how far it will be taken. My lord, in the next, my lord, in this, my lord, in this application, my lord, Section 5 was there. After that, my lord, that is the argument is there, my lord, that is in favor of the petitioner and in favor of us, my lord. That is the my contention. Say you must file one application for Section 5. After that, my lord, in the next, my lord, that is another application is filed. In this application, my lord, a restoration of a petition. First paragraph, my lord. Application has been filed for restoration in the writ petition, which was dismissed on 6 December 2012 by this court. The writ petition has been filed under Article 226 of the Constitution of India challenging the order passed by the Central Administrative Tribunal, Calcutta branch. My lord, in this matter, my lord, restoration, my lord, according to the provision of CPC, my lord, Order 9 Rule 9 is the provision for restoration, my lord. And if that is so, my lord, and if according to the provision, my lord, that is 122, Article 122, that will be applied to this case, my lord, restoration in this case. My lord, I may not. My lord, in this, my lord, if your lordship will, I may not want to go, my lord, there is details in the, I may not want to go in that. That is, my lord, last 3 paragraphs, second page. I may not want to take much time, my lord, only last 3 paragraphs. The aforesaid observation will apply in equal measure to the power of the High Court exercised under Article 226 of the Constitution. The extraordinary jurisdiction of the court, which is invoked, cannot be fettered by a statutory period of limitation. My lord, second page, my lord, last 3 paragraphs. I may not want to go into the upper page. Second page, my lord, last 3 paragraphs. The aforesaid observations will apply in equal measure to the power of the High Court exercised under Article 226 of the Constitution. The extraordinary jurisdiction of the court, which is invoked, cannot be fettered by a statutory period of limitation. It is in each case that the court will consider whether there has been any delay or latches on the part of the applicant. In the present case, we are satisfied that the explanation of approaching the court on 22nd January 2013 by way of a present application is satisfactory. We do not think that the delay in filing the application for restoration is surmountable or inordinate. In the event, the applicant cannot be made to suffer for the indisposition of the advocate. My lord, merely as the court has the jurisdiction, to inherent jurisdiction, for that reason, my lord, your lordship can't allow any application. There must be inordinate delay and other things, my lord, that must be explained in a proper way. If your lordship, my lord, satisfied about the explanation of the delay, then, my lord, your lordship can, in these two, sum and substance of these two, my lord, judgment is there, my lord. So I may not take much point, my lord. If your lordship sees that not only inherent power, my lord, you must see whether the explanation is, my lord, is satisfied before your lordship, and that is not in fettered way and anything else, my lord, then your lordship can pass the order. I may not want.
This is an application for can কত এটা? Application for restoration. Anything in reply, Mr. Basu?
My lord, I was only, my lord, making one humble submission that, my lord, let the writ petition be fought on merits. My lord, it was dismissed for default for non-appearance of a lawyer.
Okay.
Now, my lord, we have given the explanation. Now, my lord, the only argument that has been advanced is, my lord, that the restoration application does not accompany an application under Section 5 of the Limitation Act. Now, my lord, Section 5 only will be applicable when the restoration application is filed beyond the prescribed period of limitation. But here, my lord, I have satisfied your lordship by the division bench judgment that Article 137 will apply. So if Article, then, my lord, my restoration application was filed within the prescribed period of limitation. If it is within the prescribed period of limitation, the question of filing an application for condonation of delay under Section 5, my lord, does not and cannot arise. And, my lord, lordship will see, my lord, we had indicated the relevant paragraphs in the application also, that what prevented us from, my lord, filing the restoration application. There was a person concerned who was handling the matter. The concerned person died, and, my lord, each and every day's delay as to what prevented us, my lord, in applying for restoration of the writ petition, my lord, has been indicated in the body of the petition itself. But I have not seen, my lord, the state opposing a restoration application so vehemently on any other occasion. But, my lord, the writ petition may be heard on merits, my lord. Mr. They will have his right, my lord, to contest the writ petition tooth and nail. I was beseeching your lordship that the writ petition be restored. We can fight out the merits on some other day before your lordship, as per your lordship's convenience.
Then this is an application for.
Mr. Basu has already assisted your lordship. As I have been told, my lord, this application has to be allowed. Whatever they are saying on the merits of the writ petition,
Okay.
lordship will take care.
This is an
And they were
application for.
So I could have understood that they had a right of hearing or a right to oppose if they were there, and my lord, we were not there. My lord, they were also not there. So equally, my lord, guilty.
Less than you.
Less than me, I do agree. With my lord, with folded hands, I agree that.
This is an application for the restoration of the writ petition upon recalling of order dated 23rd November 2023. Mr. Rupok Ghosh, learned advocate appearing for the applicant petitioner, at the outset submits that the residuary article, residuary provision of Article 137 providing for 3 years for filing application for restoration, since the accrual of the right would apply in the present case. The writ petition was dismissed for default on 23rd November 2023, and the application for restoration has been filed on 5th November 2024 within a period of 1 year. Therefore, the question of filing an application under Section 5 for condonation of delay does not arise. Does not and cannot arise. He also indicates that Article 122 of the Limitation Act has got no manner of application to the writ petitions. It only applies in case of suits. Or full stop. To buttress his contention, he relies on the decision of this court passed in 2005 volume 2004 SCC online Calcutta 677 party number the other one. 2013 SCC online Calcutta 7828. He also submits that on the date the matter was called, there was no representation, since the person who was looking after this case was suffering from, what is his name? Was suffering from cardiac ailment. And day-to-day explanation has already been given in the application for restoration. In light of his aforesaid submissions, he prays for restoration of the writ petition by recalling order dated 23rd November 2023. On the contrary, Mr. Chundicharan De, learned additional government pleader appearing for the state respondents, indicates that in both the decisions, that is ML Bose and Company Private Limited Supra and in Shiv Prasad Chaudhary Supra, the application for restoration was accompanied by an application for condonation of delay. Therefore, the present restoration application should have been accompanied by an application for condonation of delay. Since the applicant has failed to pay for condonation of delay by a separate application, the application for restoration needs to be dismissed in limine. Upon hearing the learned advocates for respective parties, the first issue which needs to be decided in the application as to whether there is any delay in filing of the restoration application. In order to appreciate such issue, it would be apposite to reproduce the relevant paragraphs. A judgment paragraphs 18 and 19 টা quote করবেন 18 and 19 ঠিক আছে ML Bose and Company bearing in mind the proposition as aforesaid laid down, it is no more res integra that Article 137 of the Limitation Act applies to the writ petitions. Article 137 of the Limitation Act provides for a period of 3 years when the right to apply accrues. The application has been filed within a period of 1 year from date of its dismissal. Therefore, there does not occasion a delay. Stop. For such reason, the applicant cannot be called on to file an application for condonation of delay. Condonation of delay. This court finds substance in submission of Mr. Bose relying on ML Bose Company and Shiv Prasad Chaudhary Supra. Para. As far as the application for restoration is concerned, it is found that the applicant has categorically stated that the person who was looking after the matter fell sick, which led to non-appearance made on behalf of the applicant. Such cause is considered to be sufficient to restore the writ petition. Para. Accordingly, the order dated 23rd November 2023 is recalled. The writ petition being number such and such is restored to its original file and number. Is there any other application at that point? No. It's original file and number. What is the deduction to be given in the writ petition for filing the opposition?
My lord,
Writ petition heading করুন Mr. De.
It's not a party of the proceedings, so
Mr. De.
opposition দেবো কেন? Opposition দেওয়ার আগে বলতে হবে তা তো তোমাদেরই ভালো মামলাটা কি আর দেরি করতে চাও? Then my lord, that point, my lord, I filed affidavit in opposition.
May I say something with leave of my direction? Yeah? But kindly let it appear one day in the list. I am also being very candid. I have not applied my mind to the main writ petition. Kindly let it appear in the list. Now that your lordship has restored it, we will make our submissions. Depending on what we say that day, your lordship will give directions.
Okay.
February, my lord, after the monthly list, any day your lordship gives it. After February monthly list, কবে হবে?
দেখো কবে আসছে List the writ petition on
5th or 6th.
12th.
12th. Grateful.
The application to dispose of it.
So deep. Well, my lord, 12 February. 12th of February. তাও চাও দেখি আচ্ছা আচ্ছা সবগুলো একসঙ্গেই হবে 4টে 3টে
This consent application, my lord. Lord, I'm very happy to submit before your lordship.
Complied.
Yes, it is fully complied.
Complied, my lord.
Mr. Chondi Charan De, learned additional government pleader,
কি আবার চিনছেন কেন?
না এটা দিতে
files. Hi, sorry.
ম্যাডাম বাড়িতে আটকে গেছে
বসুন বসুন
হ্যাঁ
এটা ফাঁক হয়ে গেছে স্লিপ করে গেছে
একটু জল দিয়ে দিন একটু জল দিয়ে দিন তা ব্যথা হবে কিন্তু
Sit down. ওইখানে বসে নিন যান
হ্যাঁ
Mr. Chondi Charan De, learned additional government pleader,
তোমার ওই অর্ডারটা
files compliance report. Mr. Krishno Das Poddar, learned advocate,
ওরা তো বলতে পারো
appearing for the petitioner. আচ্ছা ওটা কি files compliance report তো
yes my lord I filed complaint.
and he submits that the order of this court has been duly complied with. Mr. Krishno
by delivering the title deed
by order complied with. Mr. Krishno Das Poddar, learned advocate for the applicant petitioner, also concedes to the same. In view of the above, the contempt petition being CPAN 1770/2024 stands disposed of. Where is Mr. Basu?
Your Lordship, I am for the respondent number 2 and 3. For the
Where's Mr.
Haldia
Basu?
develop. Yes, sir. Yes, Your Lordship. He is actually occupied in another court with another matter. Kindly accommodate another date for this matter, Lordship.
Then this এটা হবে না এবারে Re Anirban GP. Oh. জানতাম না so and so learned advocate for the respond number 2 and 3.
Yes, sir.
দেখে উঠুন respond number 2 and 3. Miss so and so learned advocate appearing for respond number 2 and 3. ওর কি বলে এটা না না কি ওই কোম্পানির নামটা কি আছে হলদিয়া ডেভেলপমেন্ট অথরিটি seeks for accommodation. In view of such submissions, list is 11.
Grateful, Your Lordship.
Alhamdulillah. You have concluded?
বলবে তো বলে দাও
যদি বলো বলে দাও
Mr. Pan likes to place two judgment lordships. 2012 1 SCC, 2012 5 SCC. But two judgment has already been distinguished in the development of If he raised any point, Lordship, certainly I will give the reply, Lordship, a new point, Lordship. With regard to the two judgment, Lordship, let him submit, Lordship.
এই হাতে লেখা ওই নোটটা কোথায় গেল গো?
Little difference. Before I proceed with the judgment cited by my learned friend, my learned friend has heavily relied upon that is reported in the Bondhan Development Authority. 2000, প্রথম কাগজ, under 2028 SCC, page 123, and he has relied upon certain paragraphs. Now it has been submitted that certain things have been distinguished in that judgment. Now, before I proceed with that judgment, in the context of this, I like to cite one judgment before your Lordship that is reported in 2003 volume 2 SCC, 2007-11 SCC.
On the last occasion, he placed two judgments.
One
judgment, that is 2012, 1 SCC, page 792. He only placed this judgment today before your Lordship. Nothing less, Lordship. He said that it will be continued endless for this.
The judgment of the 2007 volume 11 SCC, page 92.
given the copy.
Yes, my lord, I am handing up the copy to your Lordship. My lord, I will. My lord, I am relying on paragraph 15. This context, my lord, that while relying upon reliance of a judgment is being placed, the court should also consider the given facts and circumstances of the case and the
Which
case,
paragraph number?
paragraph 15, my lord. Paragraph 15. 2007 11 volume SCC, page 92. 11. 2003 2 তে ফোন রাখ এখন 2003 volume 2 তে
Yes.
Then another decision on this aspect also, my lord, that is reported in 2003 volume 2 SCC, page 111. A decision is an authority for which it is decided and not what can logically be deduced from therefrom. A little difference in facts or additional facts may make a lot of difference in the precedential value of a decision. My lord, this is, my lord, I rely upon, my lord, paragraph 59.
প্যারাগ্রাফ 59 এটা যশোর খুঁজি না এটা বন্ধন হতে বন্ধন ডেভেলপমেন্ট অথরিটি ওটা না বড় সার্টিফিকেটটা কোথায় গেল?
Yes.
Now, my lord, my learned friend has heavily relied upon on a judgment reported in 2020 volume 8 SCC 129. Entire judgment he has candidly said. Thereafter, he relied upon a few paragraphs of those judgment. Now, before I proceed with that judgment, but if your lordship kindly see page that what was the issue for determination of the judgment before the Honorable Supreme Court. তোমার বইটা এটা আমাকে দাও তো এটা জজ সাহেবকে দিই কারণ তোমাদের বইটা তো মিলছে না আজকে দাও না তোমার বইটা হ্যাঁ তাই দিচ্ছি তোমার থেকে ছাড়বো না আমি কিছু কোনো চিন্তা নেই
Yes.
The dispute in this judgment, my lord, what was for consideration before the special bench. But there was a judgment delivered in a Pune municipality, wherein it has been said the implication of subsection 2 of section 24 of Act 2013. Now, in Act 2013 says that, my lord, if award is not passed within 5 years or possession is not being taken over. Pune municipality said, taking into consideration subsection 2 of section 24, proceeding will lapse. My lord, another bench, my lord, decided in other way. That's why this has been referred to the 5 judges bench. Now, kindly turn to, my lord, page 133 of that judgment, page 133. My lord, these are the issues. The issues for determination of a reference to this 5 judges bench were whether the word or in section 24(2) of the 2013 Act used in possession has not been taken or compensation has not been paid, that is between the two conditions, is to be read, and that is whether the said or is used conjunctively. Second, my lord, whether the proviso placed under subsection section 24(2) of the 2013 Act has to be construed as part of section 24(2) or as a proviso to section 24(1)(b). Next, my lord, what are the meanings of paid, deposited, and tendered in the context of compensation and consequence of refusal to accept compensation, namely? Next, what is the mode of taking possession under the Land Acquisition 1894 and true meaning of the expression, the physical possession of the land has not been taken? Kindly mark this, my lord, the physical possession of the land has not been taken
occurring in section 24(2) of the 2013 Act, whether the period covered by an interim order of a court concerning land acquisition proceedings initiated under the 1894 Act ought to be excluded for the purpose of applicability of section 24(2) of 2013 Act, whether section 24 of 2013 Act revives barred and stale claims. Number নতুন বইটা আছে?
New Act.
My satisfaction, my lordship, kindly have a look at the section 24(2) once. Your lordships have gone through this several times.
No right to fair return. Right to fair compensation.
It is just listen. Well, section 24, my reading of way of understanding is this, my lord, that this is a provision provides for a proceeding which has been initiated under the Land Acquisition Act, and the fate of those proceedings in non-compliance of section 11 and section 16. Notwithstanding anything contained in this act, in any case of land acquisition proceeding initiated under the Land Act 1894, where no award under section 11 of the State Land Acquisition Act has been made, then all provisions of this act relating to the determination of compensation shall apply. Where an award under section 11 has been made, then such proceedings shall continue under the provisions of the State Land Acquisition Act as if the said act has not been repealed. Next, notwithstanding anything contained in subsection 1, in case of land acquisition proceeding initiated under the Land Acquisition Act 1894, when an award under the said section 11 has been made 5 years or more prior to the commencement of this act, but the physical possession of the land has not been taken, or the compensation has not been paid, the said proceedings shall be deemed to have lapsed, and the appropriate government, if it is so chooses, shall initiate the proceeding of such land acquisition afresh in accordance with the provision of this act. In interpreting this subsection 2, this judgment was delivered. In the process of deciding this judgment, the relevant parties who are contesting that the proceeding relied upon certain judgments. It doesn't mean, subject to your lordship correction, that this is the observation, mere observation of a court is not the law. Mere observation of a court does not bind the parties. It is what has been decided in the judgment after considering those the judgment relied upon. I may rely 100 judgment upon you up to your lordship. Your lordship quoted all the judgment. It doesn't mean that your lordship had decided all the judgment in the as per the quotation. So my learned friend has said so many things, so many relied upon so many paragraphs of those judgment. These are nothing but a quotation from a judgment. Kindly have a look at them, my lord, those paragraphs once again. My lord, here my specific case is this, my lord. I am thankful to my learned friend that he has relied upon a decision of this honorable court, if I am not wrong, that is in respect of the self-same proceeding, wherein they have said the proceeding was taken over under section 16, and that has been quoted in the judgment itself. Those plots in respect of the self-same proceeding, which is deciding by your lordship, possession was taken over by section 16, invoking section 16. I will show to that paragraph to your lordship, my lord. Meaning thereby, as I submitted before your lordship, before invoking section 17(1), there must be an opinion and there must be an approval from the appropriate government for invoking section 17(1). which is absent because they sought for invocation, approval for invocation, subsequently nothing. And which will be evident from from the judgment they have, my learned friend had relied upon in another case, that they invoke section 16. Now, in case of an invocation of section 16, what they have relied upon, my lord, they have relied upon a certificate of possession. My lord, Supreme Court has categorically said, certificate of possession does not constitute, my lord, taking over possession, because this has been prepared by the authority themselves. There is no independent witness. I was not served with the notice. You hand over the possession. No, nothing sort of that. Only a certificate of possession. Well, that has been dealt with by the Supreme Court.
Is going into the merit of the matter, then it will be.
This cannot be. Then this will be a never-ending process.
No, my lord, I tell you, but they have said it. My lord, kindly see. My lord, kindly see. My lord, kindly see. They have relied upon, my lord, they have relied upon the judgment. I am relying on that judgment. I am distinguishing that judgment.
Which judgment?
Yes, my lord, they are unreported judgment. Unreported judgment they have relied upon. I am not submitting anything new. I am citing this judgment in support of my contention in reply to that submission.
I have relied only one paragraph of the judgment. Nothing more, nothing less.
Can't be. It doesn't mean that you are relying on the judgment itself.
Now you can submit.
Yes. Yes. Now, my lord, kindly see, my lord.
Yes.
Yes.
You know, it's Land Acquisition Act.
My lord, here, my lord, your lordship kindly see in this judgment what the court has considered, what I argued before your lordship, that there is no approval of the award. That is my categorical submission after production of the record. And my lord, I categorically said that this is the notice under section 31934 was issued by the collector. So collector cannot be the appropriate authority, appropriate government for the purpose of approval the award, because he was the party to the proceeding whom award I am challenging. And nowhere in the affidavit they have said that these are the person who is functioning for and on behalf of the collector. And regarding approval, I shown to your lordship, my lord, the three signature is appearing there. First signature is of Land Acquisition Officer, followed by, my lord, the signature of the additional Land Acquisition Officer and the collector. And there is no approval of the award as has been required by this. Here, my lord, in this judgment, which my learned friend is relied upon, is an unreported judgment. This point was never been taken. So therefore, the legality and validity of the award was not under the challenge in this writ petition. Here, what happened, my lord? A writ petition was filed. Now subsequently the writ petitioner withdraw the writ petition. Then again he filed a suit. Then, my lord, he came before this honorable court. Court said, since you have withdrawn earlier, and now you are saying that you are challenging the notification of section 4C afresh. So I have not challenged any notification of section 4 and section 6 in this writ application. What I have said, that section 4, section 6 you have served, you have published. Section 9, my PDC interest was served. I duly appeared, but you did not pay the amount. Now proceedings lapse. You de-requisition, issue and formal order of de-requisition. In the process, when the record was produced, it was found that award has been declared as not verified. Absurd. Because my name in the award sheet is appearing, but subject to your lordship correction is this matter with the cost of repetition. I am saying to your lordship, if any award is been declared without apportionment, that award is nullity, because section 11 categorically said that true area of the land, apportionment and the determination should be there in the award. But in our case, nothing has been done. Therefore, my lord, considering the facts and circumstances of the case of mine, the judgment relied upon my learned friend, an unreported judgment has no manner of application in deciding our issue involved in the instant writ petition. Now, my lord, my learned friend has relied upon so many judgments, so many paragraphs of judgment. That is, my lord, paragraph.
This you have made your submissions in respect of Bholanath Kole. You have distinguished Bholanath Kole.
Yes. Bholanath Kole.
In that, the notice under section 4 was under challenge.
4 and 6.
4 and
That too, my lord, after filing the first petition, which was withdrawn, subsequent to that, withdraw after the withdrawal.
Yes.
Now, my lord, they have submitted, although state has not submitted this thing. And state has not, neither my learned friend nor the state has submitted that no, award was approved, whatever record that is wrong, or this is the portion of the award by which award has been approved. Not a single line of the records which have been handed over to your lordship, which I've collected from them, not a single line they have submitted on the basis of that. It can be said that this is the line wherefrom it will be evident that award has been approved. No submission to that with that regard, either by the state or by the recording body. পজিশনটা দিত পজিশনটা ওই যে জাজমেন্টটা দিলি জাজমেন্টটা দি এখানটা দে না সিম্বলিক পজিশন যেটা symbolic position. Now, my lord, regarding my lord the possession, they have referred to my lord paragraph 136, 137. One 36, your lordship kindly see the judgment of the In Satyendra Prasad Jain, the concept of vaccine under section 8 under the 1894 has been taken into consideration. The government cannot withdraw from acquisition under section 48 once it has taken possession. My lord, these paragraphs should be read, my lord, as per my way of understanding is with paragraph 138. Satyendra Prasad Jain, my lord, has my lord said that where section 17(1) is invoked, 11A has no manner of application. My lord, I shown to your lordship at the very first moment every judgment should be read on the basis of the given facts and circumstances of the case. Now, my lord, in a similar situation, my lord, regarding invocation of section 17(1) and applicability of section 11 capital A has been dealt with by the Supreme Court, and wherein this has been clarified that under what context the Satyendra Prasad Jain case will be applied. It cannot be, my lord, the sacrosanct or in respect of any other thing, because, my lord, your lordship knows it's a Land Acquisition Act or any other, my lord, the Act 2013 is a beneficial legislation. If this is the sacrosanct, my lord, when award was declared, possession taken, state wanted to withdraw from the acquisition. Satyendra Prasad Jain said, no, you can't. Being a state, you cannot withdraw these things. You have taken over the possession. In my case, my lord, my possession, I am still in possession. I am still in possession. Now, my lord, if your lordship kindly see this judgment reported in 2015-10, Supreme Court cases 241.
He is placing new judgment.
My lord, definitely, my lord, he is relying upon a judgment, my lord, that has not been placed earlier. So I have to controvert this thing. I have to controvert because you are heavily relying Satyendra Prasad Jain.
I'm very sorry.
So, my lord, I have in reply, I have to, my lord, I must get an opportunity.
I'm very sorry to.
Because you have gone, my lord, kindly see, my lord, they have gone beyond the scope of the writ petition, which is not their case even. Which is not their case made out in the affidavit. They have not restricted themselves to the affidavit only. This relying upon a judgment. We dealt in a subsection 22 of section 24, which is not our case in the writ petition. If he can rely on this judgment, my respectful submission before your lordship, my lord, I have to answer these questions. They are relying upon a judgment, my lord.
I'm not obstructing lordship. Let him continue, lordship. Then another chance will be given to go to my respectful submission on the previous day. Long after delay, after taking acquisition, completion of the acquisition proceeding, there is no scope to reopen the same. Amount of decision, lordship, from the Supreme Court, lordship, still from the date of 2020, thereafter, lordship. That was my submission. After 13 years, he has come here before lordship, raising all such points. We have told several lordship there is no scope to challenge this proceeding in such way. And they cannot challenge the procedural thing of acquisition when the acquisition has already been completed long back. That was the submission on the previous occasion and different judgments of this. And he told on the last occasion, two judgment lordship, 2001 SCC and 2005 SCC.
Mr. Khan, you should have argued this point because, see, there is a 5 judges bench decision which is known to everybody, and what are the points of consideration before that court. Now, this argument you should anticipate that this sort of argument will come. A delay in the proceedings, it is there. Please let me complete, then you will argue.
Sorry.
If this sort of practice is allowed, then there will be a never-ending process. Because he will come up with the next day he will also come up with a reply.
My lord, I'm sorry. I am extremely grateful to your lordship. My lord, I will restrict myself to the judgment.
You are here. If I don't get the assistance and the confusion arises one after the other.
I bow down to your lordship. I bow down to your lordship.
Then,
my lord, I will be restricted myself to the relevant paragraphs of this judgment and reply thereto. My lord, if I can satisfy your lordship, that the delay dealt with in the different facts and circumstances case and delay in the matter of my lord, my lord, for the purpose of determination of compensation and the proceeding, my lord, in the process.
Please do that.
Yes,
Please.
that is exactly what I am on. My lord, kindly see, my lord, he is heavily saying that moment the award has been declared, I cannot do anything, I cannot challenge everything. But Supreme Court says, my lord, with greatest my lord, respect, that illegality of an proceeding can be addressed even after declaration of the award. My lord, will your lordship be kind enough to permit me to hand over this judgment? My lord, this is pertain to the delay and laches. I will cite two judgments before your lordship, and one's judgment very well known to your lordship, that is Vidya Devi, which is a continuing cause of action. And delay, I am not claiming, I am not asking for, my lord, challenging the notification of section 4 and section 6. I am saying that
Then I will go back to them.
my lord, my lord. Now, my lord, kindly see, my
Then
lord.
I will go back to them.
My lord.
If you start submitting the decisions, then I will go back to them, have their response also on these judgments.
My lord, kindly come for the ends of justice. For the ends of justice.
For ends of justice, what I am saying is, now he has concluded his argument. If you come up with decisions, I will give him an opportunity to respond to these decisions.
My lord, only this decision. Kindly allow him.
Not only these decisions, you can place 5 to 10 decisions.
But
Now it is open to you.
never mind. I never mind. Let them
Then
answer,
they
please.
will respond to that decision.
My lord, my lord.
If it is a point of law, let them come up.
My lord, let them decide.
Sir, you will get your opportunity. Now I have said, let him place whatever he wants to place. Come up with the response.
My lord, this is
Never
the judgment reported in. Here also, my lord, the award was declared. In this proceeding, award was also declared under section 11. This is a proceeding reported in 2016-6. Supreme Court cases 150. My lord, just one paragraph. It's a very short judgment. Only, my lord, paragraph 15. It is Joseph Kedina. This is paragraph 15. 2016-6 SCC 150.
Paragraph 15.
Paragraph 15. That is one judgment.
Yes.
This is my contention. Because I was not served, kindly keeping in mind, your lordship, my lord, I was not served with any notice under section 12(2), inviting me to accept the award, because according to them, award declared not verified, so they deposited the money with the court, and I was not aware about all these things. So question of delay does not arise. And my lord, লক্ষ্মী দেবীর আরেকটা জাজমেন্ট আছে না, জোসেফকে দিয়েছিলাম। আচ্ছা, no, this is the judgment. In reply to the, my lord, the paragraph 136. In reply to paragraph 136, my learned friends relied upon that Satyendra Prasad Jain
Yes.
This is reported in 2015-10 SCC, paragraph 2, page 241, paragraph 26, 30, 31. অত পারা যাবে না বলতে।
Tell him. Para 26.
Paragraph 26. Paragraph 26. The similar question was cropped up before the Honorable Supreme Court. And dealing with the judgment reported in the Satyendra Prasad Jain, paragraph 20, 21. Kindly before that matter, kindly turn to 21. Dealt with the Satyendra Prasad Jain. Then
Yes.
Then Mala 22, a constitution bench has reflected on the true nature of ratio decidindi in Krishnakina coined by Union of India as in discernible from the following passages. The doctrine of precedent is being bound by a previous decision is limited to the decision itself and as to what is necessary involved in it. It does not mean that this court is bound by the various reasons given in support of it, especially when the content propositions wider than the case itself required. This is what the Lord said in such and such. Judicial authority belong not to an exact word used in this or in this judgment, not even all the reasons given, but only to the principles accepted and applied as necessary grounds of the decision. In other words, then my lord, following a 3-year judgment made on page 23, it's a very important paragraph 23.
Yes.
And my lord,
Yes. Yes.
and my lord, paragraph 24. Before I move to the my lord, paragraph 26, can I have a look at the my lord, paragraph 24?
Yes.
Now, my lord, what was the issue before the bench was, my lord, at paragraph 25?
Yes.
Now, my lord, now can you turn to my lord, page 20, paragraph 26?
Yes.
Then, my lord, after discussing all these things, my lord, in paragraph 20, for respective paragraphs, paragraph 30. We feel it imperative but to distinguish between the setting aside of an acquisition and the reversion of possession to the erstwhile landowners. While the LA Act and the judgment discussed above do not allow for the latter, we are of the considered opinion that this does not necessarily imply that the former is also not an option. Both the above mentioned cases dealt with a factual situation in which the, my lord, kindly mark this portion, my lord, which the government was attempting to set the acquisition of the land at naught, so that they would not have to pay compensation to acquire it. Setting aside of the acquisition in those cases was tantamount to reverting the possession to the original owners. In this scenario, however, the two do not have to go hand in hand. In allowing the acquisition of land that the government find necessary to be set aside, we would necessarily be holding that the land revert to the appellant as the alternative of permitting the government to keep possession, provided it requires the land with a new section 4 notification exists. This opinion, particularly in the present factual matrix, does not list violence of the intent and content of LA Act in that it affords section 11 even in cases of acquisition under section 17, while preserving the requirement of section 17 that the unencumbered possession of the land remain vested in the government. It also protects the rights of the landowners, thus fulfilling the intent of section 11 capital A, while allowing the government to acquire land in cases of emergencies without its title being challenged, which is about intention of section 17. Any other interpretation of the law would serve to the protect only those landowners who had approached the court to stop the government from undoing an emergency acquisition, while living in the cold, equally equipped landowners seeking to enforce their right to fair compensation of their land. Even equity demands that the party bearing the consequence of the delay in the award ought not to be the innocent landowner, but the errant state. My lord, surprisingly, my lord, my land has been taken over according to them. Award passed, not sustainable in the eye of law, saying not verified, so I need not to be served any notice.
Let him continue from the beginning, Lord. It's better, Lord.
Now, my lord. Yes.
Any other decision?
Yes, my lord. One more decision, my lord. এটা কত প্যারাগ্রাফটা কত প্যারাগ্রাফটা কত হ্যাঁ এটা 2012 one SCC হ্যাঁ My lord, this is the judgment. My lord, they reported in my lord, 2012 one SCC 792. Element 12. ঠিক তো হ্যাঁ 20 yes now my lord in this judgment I am relying upon paragraphs 11 12 14 16 17 18 and 20. Here, my lord, kindly have a look at the paragraph 20 first. Here also, my lord, the certificate of possession was relied upon, but this was done unilaterally by the government authorities. without any independent witness. আর কোথায় In respect of the matter, the taking over possession, they have heavily relied upon the matter, the document I have annexed at page 24. No, that is not the page 24 of the affidavit in opposition. Wherefrom it will be evident, my lord, that there is no independent signature of independent witness. Affidavit in opposition, my lord, page 24.
Yes.
Now, my lord. Lord, admittedly, my lord, there is no delay on my part, as it is a well settled principle of law, my lord, that this is a continuing cause of action. Now, my lord, here is the laches. Is a deliberate laches and negligent on the part of the my lord, the collector and his subordinates. And to patch up this thing, my lord, they cannot take the plea of delay and laches on my part. But this is the situation that has been dealt in by the Supreme Court reported in reporting case. My lord, 2022 volume 2, page 301. My lord, the only one paragraph, my lord, paragraph 38. It is Joseph ke din na ekটু এটা কে তোমার বই?
দুর্বল কেস।
তোমার বই কেন? কথা বলি? হ্যাঁ, কম্পেনসেশনও দেবে না। Now, my lord,
This one was the last one.
my lord, this one is the last one. I will not cite any judgment. This one, my lord, I
Mr. Pan will not stop.
no, my lord, I will stop here and now, my lord. I will stop here and just to
Which
my lord,
paragraph?
summarize the my lord, paragraph I told you 38. My lord, paragraph 38. আরে তুমি তো আজকে বলছো আমি শেষ করব এখন তুমিও শেষ করো না my lord, now to summarize my reply, my lord. স্যার আমরা কাই পরে দিয়ে দিচ্ছি পরে দিয়ে দিচ্ছি This petition to কোন প্যারাগ্রাফে আমি বলেছি পজিশনে আছে ফিজিক্যাল পজিশনে আছে
Give a copy of this judgment. Give a copy of this judgment.
But I will hand up all the copies to your lordship, my lord.
Okay.
Now, my lord, to summarize my submission, my lord, I submit before your lordship, my lord, that in this proceeding, I have not challenged any section 4, section 6. What I have said, that in connection with the section 4 and 6, I was served with a notice under section 9. And I duly appeared, I submitted all the documents to the satisfaction. And there is no denial to this, that I have not appeared, I have not satisfied the document. Now they kept themselves silent. When I was in possession, I was tried to dispossess. Then, my lord, I moved this writ application before this honorable court that look, that the proceeding has lapsed. So you issue a formal order of acquisition, the acquisition, formal order of, because it's a proceeding under Act 1. Now, when they have come up with a case, my lord, that award has been declared and possession taken over. To this, they cited special bench judgment, etc. Then, my lord, record was produced, wherefrom it will be evident, which is a mandatory in nature, that before passing of award, approval is must. Record produced, wherefrom it will be evident, no approval was accorded, although sought for, but that has not been accorded. Now, my lord, in two phases, award was passed. One, in respect of those land were verified, that cannot be done also, my lord, in the two phases, the award can be had. Second award, I fall under the category of the second time, which has an award declared. Then, my lord, that has approval has also not been accorded. And, my lord, as non-verified award, which is absent in the statute, that has been deposited with the court. That is their case. Now, my respectful submission before your lordship, my lord, the judgment cited by my learned friend has no manner of application considering the facts and circumstances of the case. I get foot to your lordship. May I take your lordship leave? May I take your lordship leave?
Go through the judgment. Where is Mr. Dey? Hmm.
In paragraph 365 of the 2020 prudent standard. This is the overrule. Paragraph 365. Only in the development authority, page 365.
Pune, he has not referred?
My
No, Mr. Pan has not referred or relied on Pune. Then?
The judgment was overruled. Not only that, the citation made in Pune municipality cases, all are overruled. And there's a gap of the submission on the basis of the Pune municipality. So one thing, lordship, the judgment which has been relied by the full bench Shakti in the development authority are all good laws still today.
Okay.
There is no lordship. If there is a laches for a long period or taking the challenge of that particular acquisition, you need not to go into the merit of the matter, lordship. With lordship paragraph, I'm reading lordship paragraph 359, last few lines, lordship of the development authority. Paragraph 359. Last few lines, 5 lines. Whatever may be the case, lordship, there is no scope to challenge the closed acquisition at the belated stage, whatever may be the merit of the matter. If award paid or not, if position was taken or not, in accordance with the law or not.
Yes.
Applying to lordship, that has been stated in 2008. There is also a good law lordship still today relied by Indo Development Authority, which was relied by our single bench, our division bench, as well as by the apex court in unreported judgment. I think, lordship, thereafter, there is no scope to touch the merit of the matter. It reaches finality.
Yes.
Number two, there is no scope to withdraw the proceeding under section 48 of the Land Acquisition Act 1 if the position be taken. In our case, position was taken. Question 4, section 48, last line. Except the case provided under section 36, the government shall be at liberty to withdraw the acquisition of any land of which position has not been taken. Here the position has been taken. Number 3, section 101 of the new act, the 13 Act.
Okay. Yes.
There is a provision for it is absent in Act 1. It is not applicable in Act 1.
In Act 1, only to section 48 can be returned after withdrawal of the.
Now, how does it? Act 1, the land acquisition under Act 1, 1894, is a closed acquisition, closed. And Act 13 is ongoing acquisition. And there is a scope to interfere with regard to the closed acquisition. Several judgments have placed in the development authority. Last lordship, the division, our single bench, as well as division bench, as well as on apex court, relied upon the same thing. Page 15.
Yes.
Last paragraph of page 15. There is our single bench decision relied upon Supreme Court judgment 2008 applied to another. Of the the petitioner has filed his deed application long after completion of the application under the relevant provision of Act 1894. Thus, challenge the writ petition has become stillborn due to passage of time. Accordingly, the writ petitioner does not merit consideration and stand dismissed. There shall be no pause. That is the same thing to the application, the long observation of what this point by the honorable application.
Yes.
I think the also submission made by the landed trade. There is a scope to consider at this stage, after completion of the acquisition and long after acquisition, taking position has come to challenge the acquisition proceeding. I think lordship need not to give other answers, other points and lordship that full bench petition of the honorable apex court has not been touched in by judgment by one petition being or special judge.
That's all.
All such secrecy that is considered duly, very carefully by the division by the bench of the Honorable Appellate Court and pass that order and that upon lordship. Also, the decision lordship, then 364, 360, paragraph 363, 364, 365. Follow the regiment lordship 443 of the in the development of city. I'm not wasting the time of your lordship. Thanks, because the other senior member of the respective senior member of the waiting for number.
That's all.
That's my
Okay.
If any point does have not come to the judgment of the if any point be not covered by the decision of the order of the Appellate Court. Question by the petition. Question 20. If an opportunity to revert the judge, if required.
What were you doing all this time? Where is Mr. De? Call him if he wants to make any submission with regard to the judgments. Sir, enough time has been given. দেখো তো ফ্রাইডেতে কি আছে ফ্রাইডে তবে শুধু ওপেন নিয়ে নাও শেষ করেই যাচ্ছে নেক্সট ওয়েডনেসডে আই উইল নট বি হিয়ার তবে ফ্রাইডে রাখাটাও মুশকিল না যাওয়ার আছে আপনার হয়ে গেছে সব আপনার প্রসেস কমপ্লিট সে কি ঠিক আছে টিকিট কাটা হয়ে গেছে তো ওনাদেরটা পাঠিয়ে দিয়েছি আমি কিন্তু আপনার নামটা তো আমি ইনক্লুড করতে পারিনি এইটাতে রাখবো না ফেব্রুয়ারিতেই রাখবো তুই যা রিপ্লাই করবে করা বুঝেছো এর মধ্যে হবে না next week I will not be here for next 2 weeks right in the month of February then or Mr. Amit Kumar Pan who makes his replies who concludes his replies Learned advocates for you are for respond number 4A added respond number 4A and the state respondents seeks to respond to the advocate for added respondent 4A and state respondents seeks to respond to the point of law advanced on behalf of the petitioner. Fifth chole jaओ 5 तारीख এটা আমাদের চেক করবেন নেক্সট
Five.
Yes.
Affidavit of service.
Permits. You have given a copy?
Yes, sir.
All the copies have been given? Copies have been given.
Affidavit of service. I'm not for the respondent.
Mr. Tulsidas is for the respondent, madam.
You are for whom?
No, I'm representing him, madam. He's
You are-
engaging in court number 11, madam.
In this matter, you are appearing for whom?
Yes, madam. Mr. Tulsidas, madam, for the state, madam.
Where is he?
He's engaging in court number
Where? Then who will argue this matter? Mr. Ali, he has almost concluded, but since he was not there, I have asked them to serve a notice. Now, this is the second day. Mr. Ray, on the last occasion, said that he is not having the copy of the. Then somebody has to make the argument. You conclude the argument. Huh? Then what?
Continuing matter.
In presence of Mr. Ray, this matter is posted today as top 3. When he will argue then? Huh? This is difficulty, no? At the time when I'm fixing a date, you should indicate that you are not ready or this is your predicament.
Any date, madam.
But I have got no option. You are not keeping any option open to the court. He has complied each and every direction of the court. He has given the copy to Mr. Roy.
One just, madam.
Difficulty.
It's a humble submission, madam. Give him one
ঠিক
chance.
কালকে হতে পারে?
Yes.
কাল হবে না। এই 17th এ।
তো বলো না 11টা কোর্ট, এটা কোর্ট না?
পতেরো মতো পারবো না, 17 জানুয়ারি থেকে একটু কম রাখতে হবে, কেন অন্য কিছু তো রেকর্ডস করে 16th অব্দি জমবে, তো সই করতে হবে না, ওনাদের তো টাইপ করতে হবে, পারবে না। See, the difficulty is that this matter will go in the month of February. Because I have 2 days, I have to go to Jalpaiguri on the next week. Should understand why these short dates are being given. He has argued, and the month of February it will go. What?
Could it be accommodated in any way on the 17th?
17th is the last date I am holding in Calcutta, so I have to sign the order. 17th not. That's why I'm asking. But 16th is totally. There are several matters. Mr. A achen, Mukherjee achen.
Tomorrow.
Chair of Planet. Huh? No, tomorrow it will not possible. 5th and 5th. 5th.
On top, my lord.
5th on top. Top is the 5th.
5th February on top.
AG matter 6th. Then the top একটা দেব। কোনটা? ওটা ইনফর্ম করে ওটা নিচে করে দাও না, এই অ্যাসাইন ম্যাটারে যেটা আছে 5th এ, ওটা নিচে এটাকে করে দাও, এই যেটা আগেরটা শুনলাম, তারপর এটা 5th। Mr. Ali, 7th top.
7.
On the prayer of learned advocate for the state respondent, is this matter on 7th?
My lord, item number 6, I'm for the petitioners, my lord. On the last occasion, I had concluded my submission. State was supposed to reply.
That's amazing. They're pretty good.
It was available.
The writ petition has been filed by one Sea Garden Resort Private Limited, represented by the managing director named Mahesh Kumar Agarwal. But at the time of purchase of the land, Mahesh Kumar Agarwal was not the director. If your lordship kindly come, page 2 of the cause title. Page 2 of the cause title.
Yes.
Petition Sea Garden. Then, my lord, the two, the Mahesh Kumar Agarwal. Now, my lord, come page 29. The deed itself discloses that the managing director, Sri Vivek Bardotia, and he is the award. So entire description is totally misconceived. He is claiming that he has not got the compensation money, acquisition proceeding bad, procedural lapses.
Yes.
Now, my lord, kindly come the prayer in the writ petition. Page 25. A writ in the nature of mandamus commanding the respondents from giving any effect or further effect to the impugned deed of lease, which was made between the West Bengal Industrial Development Corporation Limited, WBIDC, and the Ganapati Floor and Foods Private Limited as annexure C to the petition in respect of the land of the petitioner, commanding the respondents not to acquire the land of the petitioner for developing Vidyasagar Industrial Park and setting up of manufacturing, industrial and commending the respondents not to set up floor mill, atta mill, accessory, spare parts, which products, manufacturing unit in that. This is the prayer. Here there is no prayer that acquisition proceeding was bad, LA proceeding lapsed. There is no such prayer. LA proceeding lapsed, LA proceeding irregular, LA proceeding, there is illegality in the LA proceeding. My lord, in this regard, my lord, I want to first rely upon the decision of the Supreme Court. My lord, this is reported in 1988 4 Supreme Court cases, page 534. Only one paragraph, paragraph 13. This is the 3 judges bench. Oh, sorry, 2 judges bench. Division. Paragraph 13. 1 3.
Yes.
As has been already noticed, although the point as to the petitioner as profiteering by the state was pleaded in the writ petition before the High Court as an abstract point of law. There was no reference to any material in support thereof, nor was the point argued at the hearing of the writ petitioner. Before us, also, no particulars and no facts have been given in the special leave petition or in the writ petitions or in any affidavit that the point has been sought to be substantiated at the time of hearing by referring certain facts stated in the said application of by HSIDC. In our opinion, when a point is which is ostensibly a point of law is required to be substantiated by facts, the party raising the point, if he is the writ petitioner, must plead and prove such facts by evidence which must appear from the writ petition, and if he is the respondent, from the counter affidavit. If the facts are not pleaded or the evidence in support of such facts is not annexed to the writ petition or to the counter affidavit, as the case may be, the court will not entertain the point. Here my point is this: he is now the consequential relief time the proceedings left. His acquisition of land is bad, but in the prayer it has not been made. And that supporting to that, no document, no affidavit has been submitted.
Yes.
Now, my lord, in my affidavit in opposition, I have dealt the everything. If your lordship kindly come to my affidavit in opposition, affidavit in opposition on behalf of the respondents number 1, 2, 3, and 4. My lord,
Yes.
My lord, my lord, page 3, paragraph B. The subject matter of challenge in the petition is the acquisition of land under Act 1 for public purpose for setting up an industrial park near Kharagpur town measuring about 84.135 acres, including the plot number 86 and 86 by 332. This is the relevant plots of the petitioner. The case number is, my lord, this is to be noted very carefully, my lord. LAP 14 of 2006 and 7. In entire land was acquisition in LAP 2 of 2006 and 7. That was challenged by several petitioners, and already decision has been come, that has been reported, and my lord, I will come there, and that has been reported, and that has been affirmed by the division bench. And I heard that some SLP has been held, SLP was filed for more than 2 years ago, but I do not know what is the result of that SLP. But because, my lord, I do not think, my lord, if there would be anything that would have been, my lord, then, my lord, my landman can say that in the result of the SLP, if they are one of them. Now, my lord, this is the case, my lord, and my lord, C and D, my lord, this is the proposal that it was published in their two newspapers, the Times of India and the Ganashakti Patrika. Paragraph C, notification. Then, my lord, 5A objection, Ganashakti and Ajkal Patrika. Award was approved. Here it is, my lord, Mr. Pahan is arguing that award was not approved or anything. Here award was approved by declaring the collector on 30/1/2008, and payment of land acquisition commission was made such and such that out of 4,007 or 8 awardees, 400 has been paid. In paragraph 5, my lord, I have cited that reported decision. My lord, I shall give the, my lord, this is the, my lord, the reported decision. My lord, I am placing the facts, thereafter, my lord, the decision. This is the decision, my lord. Only one thing, my lord, I am pointing out that in this decision, my lord, that plot number, kindly see, my lord, the plot number, case number.
Same.
Same. Now, my lord, paragraph I, page 4, last paragraph. The petitioner in this case are not the awardees. He is not the awardee. Amongst the awardees, he is not. Of the plot such and such, district Paschim Mednipur, the award in respect of such and such has been framed. Well, first of the Vivek Bajoria, who is the, my lord, the in the deed whose name appears, he is the, my lord, the awardee. He has not come forward before this honorable court. And others. On page 5, my lord, kindly see the name. Award serial I have given. That is in respect of plot number 86. These are the awards.
Vivek Bajoria has been paid.
He did not receive. He is the awardee. Award has been passed in his name.
So the amount is lying with the district judge. Now, how this Mahesh Agarwal comes into the picture?
I do not know. Mahesh Agarwal is the petitioner. He has not described him, then under what capacity he has come to the petitioner.
Okay.
But according to the deed, Vivek Bajoria is the purchaser. And my lord, in respect of the reply to paragraph 4,
What is stated in para 4?
it has not been dealt with. Only deny and dispute. My lord, ওদের পজিশনটা আমাকে যেটা দিয়েছে my lord, if your lordship kindly come page 3. হ্যাঁ স্টেটের হয়ে ওদের রিপ্লাই, তাই তো? রিপ্লাই অন behalf of the yes. Paragraph 4. The statement made in paragraph 4 of the opposition are mostly matters of fact and documents. The deponent does not admit anything which is contrary to or inconsistent with the true fact, documents or records. For other averments made therein, the petitioner do refer and rely upon the statement made in the writ application.
This reply. This is page number, where from are we?
Page number 3, paragraph 4.
The reply of Mahesh Agarwal?
Reply, my lord, replied by Mahesh Agarwal. In respect of the affidavit in opposition by respondent number 1, 2, 3, and 4. There are two opposition.
Okay.
One by the my lord
এটা দেখো তো, এটা রিপ্লাইটা কোথায় আছে? Affidavit in reply to the affidavit in opposition of the state. এটা তো রেসপন্স নাম্বার এটার হল, এগুলো সব এক জায়গায় করো না।
affidavit in reply that has been
Against the state.
my lord, against the state. 1, 2, 3, 4. It has been affirmed on 23rd day of July 2023.
না, এটা তো অপোজিশন, এর রিপ্লাইটা। এটা এগুলো সাজিয়ে দাও, খুলে দিয়ে পরে সাজিয়ে নেবে। এখন দেখে নি কি বলছে। Yes, para 4.
Para 4. That the statements made in paragraph number 4 of the said opposition are mostly matter of facts and documents. This deponent does not admit anything which is contrary to or inconsistent with the true fact, documents or records. For the other averments made therein, the petitioner do refer and rely upon the statement made in the writ application as well as the supplementary affidavits affirmed and filed by them at the time of hearing. In the affidavit in opposition, it is a specific averment, a specific case of the state that the petitioner is not the awardee. Award has been passed in the names of such persons. Neither it has been denied, not specifically said that these are not the true facts or these are, there is no such denial. If your lordship kindly see the my lord entire paragraph 4, I have written several and particularly the 4 subparagraph I.
Yes.
My lord, it is the settled principles of law that my lord, the collector will not make roving inquiry who is the present owner. He will go by the records. The record says in the deed Vivek Bajoria. There is nowhere his name appears either in the record of rights or any document before the collector that he is the owner of the land or he can claim any right, title, interest in the property. My lord, in this regard, my lord, I want to cite a judgment. My lord, whether, my lord, it will take another 15 or 20 minutes.
Okay. Mr. नाम तो दिए थे learned advocate for state respondents. Due to paucity of time, the hearing could not be concluded. Is this matter on? Copy the 12th February. বইটা দিয়ে দিন। Give a copy of the.
I will give the Xerox, my lord. 12 February, my lord. My lord, let it be, my lord, at the top.
Top.
My lord.
Next matter, my lord.
Yes.
Item number 7. So, Shoktilar pleading since the
Oh.
Can it be fixed in another day, my lord? Because the state wants to file a report, my lord. They are present.
Another date for filing report. Is 7th दिन तो 7th. Oh. He is online?
There, my lord.
Yes, sir. Who is appearing for the state?
Mr. Chandicharan Dey is appearing with the state. I
Yes.
understand from my learned junior, Mr. Chandicharan Dey wanted to file the report. And for that, they want to take a time. They were all present at the morning.
You are there for the state. You'll be filing any report. Acha. Mr. Shokti-Nath Mukherjee, learned senior advocate appearing for the petitioner submits that pursuant to order of this court dated 2nd January 2025, notice has been duly served upon the learned advocate and Mr. Chondi Charande, Mr. Chondi Charande, learned additional government pleader. Ms. So and so, learned advocate appearing for the state respondents, seeks to file a report in the form of affidavit. Let such report in the form of affidavit be filed. Within a period of 2 weeks, exception thereto if any be filed within a week thereafter. 3 weeks for a matter at least.
Grateful.
After 3 weeks, Mr. Mukherjee.
Grateful, Lord.
10th February. 14th February. Okay. 14th February, Mr. Mukherjee.
Grateful, Lordship.
Thank you, sir. করার পরে দেখবেন, sorry, 14th.
না সে তো ছবি আছে